Item number 1.
My lord, your office has directed the state council to take instruction. What is the stage of construction? What is up to?
I have received a letter from the concerned district office. Kindly give us 2-3 weeks time to file our counter.
No, what is the stage?
The counter has been filed, my lord, but
The
your
status,
office has directed
yes.
that regarding the stage of
Status of
construction.
the year.
What happened, my lord? A multi-purpose plot shelter.
Has it been constructed or not?
Yes, that is what the BDO has written letter that one because
The collector
I will,
said that
1 week time may be granted. I will next Monday I will give the status report.
All right, Mr. Manthi, praise for, and it's granted. So it's time to file a counter affidavit to explain the current state. We'll have an opening date, 22nd June.
22nd June.
Item number 2.
May I please, Your Lordship? Here only 4 or 5 days back they have served a counter after taking 3-4 adjournments. I only pray, my lord, 1 week time.
Time for rejoinder.
All right, rejoined to be filed for the next date. 28th June. All right.
Obliged.
Item number 3.
May I please, madam? Last time I directed to make a deposit. I made the deposit. My friend wants a copy of that. I'm handing over a copy. My friend, here my friend has appeared. Has appeared before admission. After before admission, I'm serving a copy. Deposit, 1 week deposit and my matter is hard.
That calculation sheet just now he has handed over.
Okay. A sum of rupees 323272 has been deposited by the appellant in the court by way of a check, along with the calculation sheets. That said amount be now,
I may be allowed some
the check
time.
be encashed and the amount be kept in a fixed deposit in a nationalized bank. Initially for a period of 6 months and will be kept renewed during the pendency of the appeal. A complete set of the paper book be served on Mr. Ratha, who will understand the counsel for the respondent, along with the calculation sheets. List on 27 July.
Item number 4.
No. Well, I have served the written note also in this case. I have filed the written note in this case also.
All right.
Item number 4.
May please, Your Lordship. My lord, order dated 19/10/2022 on the challenge of Honorable at Annex 4. I have given a similar. But my lord, that case is
Same order.
11th of
May.
this month. Okay.
Item number 5.
In spite of your lordship direction, the petition did not serve the copy of the
Pardon, my lordship. Item 5, my lordship, permitted to withdraw, my lordship.
All right.
My lordship.
Counsel the petitioner seeks leave to withdraw the present petition. Dismiss.
My lordship. Obliged, my lordship.
Item number 6.
Item number 6, Your Lordship. Here I am praying for inquiry into malnutrition deaths into the Jajpur district, Your Lordship. And there are still several who are still suffering, Your Lordship, also.
My lord, I think the similar matter is pending. Your lordship has directed the CDMO to inquire about the matter. And
That is not kidney thing, sir.
That is
that
kidney.
TB. That
This
is
is
TB.
malnutrition.
This is
That was Jagat Singhpur, I think.
No,
No,
Jajpur,
that
Your
is
Lord.
Jajpur.
That
That
both
is
are
also
Jajpur. That is kidney related disease.
Yeah. When is that coming up?
That
My
is,
lord, my lord, kindly, after 2 minutes, I am giving the date. Just I am.
All right. You see, the present petition
I will give it to court master.
highlights the plight of very young children. Many of them belonging to the scheduled tribes.
Your Lordship.
Who are dying due to in the
ସେଇଟା ବି ମଣ୍ଟୁଟା ଆସିଥିଲା ନା petition?
in the Danagadi block and mostly from villages Ghati Sahi, Kiajhar, Salin Jagha, Nadia Bhanga, Dhuligad, Chania, and Anagundi in Jajpur district. Who are suffering from suffering from chronic malnutrition and living under semi-starvation and prolonged hunger. Full stop. They are vulnerable to diseases and many have lost their lives. Full stop. Paragraph. Another issue that has been highlighted is that in the absence of Aadhaar cards, these children get completely excluded from the public distribution system and other welfare schemes. Full stop. It is pointed out that in the Ghati Sahi village, only 160 out of 309 villages have Aadhaar cards and therefore are unable to get the monthly quota from the public distribution system. Monthly quotas from the public distribution system. The instances of children dying of malnutrition have also been highlighted in the petition. Full stop. It is obvious that this requires immediate attention at the hands of the state government, as well as the Union of India. See, notice Mr. Mohanty accepts notice for opposite parties.
For 1 and 2 we are there.
28th June.
3 to 7 and 9 to 11. Notice will now, you say Mr. Padi accepts notice for, sir, opposite parties 1 and 2?
1 and 2, yes.
1 and 2.
Right.
Stop. The court would like the court directs that both the Principal Secretary, Women and Child Development Department, State of Orissa, as well as the Union Secretary for Women and Child Development, Union of India, will file their respective affidavits, giving a para-based reply not later than 15th May 2023.
In that case, may
In the meanwhile, the collector Jajpur will undertake a personal visit
may I interfere?
to the
In that case, your lordship has directed the CDMO Jajpur to conduct an inquiry and submit the inquiry report, and the date is fixed to 28th June.
but I think this requires some immediate attention, sir.
Yes, my lord.
The collector Jajpur to undertake a visit to the
Along with CDMO.
Yeah. to the Danagadi block,
Affected areas.
and in particular the affected village, including village Ghati Sahi, along with the CDMO Jajpur, and submit a report to this court before the next date. The collector Jajpur and the CDMO Jajpur are also requested to remain present online, as will the Union Secretary, Women and Child Development, Government of India. So the respective council will intimate this to them forthwith. Full stop. List on 18th May
My lord, may I submit that this order be communicated to the government only? I will.
Yes, yes. This order be
Additional
communicated
Chief
to
Secretary
the
to Government, Health and Family Welfare.
Principal Secretary, Women and Child Development, Government of Orissa,
Additional Chief Secretary.
Additional Chief Secretary, as well as the Union Secretary, Women and Child Development, Government of India.
Item number 7.
My lord, may I reflect Mr. Bhukta along with me, madam.
All right, all right.
Deep Luminous.
Item number 7.
I may pardon, my lord, item number 7,
Yes.
this writ appeal, my lord, the returned candidate has been thrown away without adjudication. My lord. What has happened? Application has been filed under 44B of the Panchayat Samiti Act by the respondent number 1, and that application was objected to on the ground that it is barred by limitation. And a petition was filed to take up the matter under Order 14 Rule 2 CPC. And it was held that the petition is barred by time and rejected.
The term itself must be over now, no? 2017 means the term itself must be over now. When did the election take place, sir?
2017. my lord.
By now it's all over, sir. We are in 2023. No point. You say the election is of 2017. And the period for which the candidate in question was elected is also over. Leaving the questions of law raised in the present appeal open for decision some other property case, the appeal is disposed of.
Item number 8.
May I please, Lordship? My lord, the impugn order is at page 21, my lord. Here on the first date, the matter has been directed to be disposed of. Lordship, may kindly see page 21. The learned single judge, my lord, with due respect, has proceeded as if it's a suo motu contempt proceeding without issuing notice. It has been directed that the direction issued by the learned tribunal may be complied with. The learned tribunal had directed to work out the pensionary benefits of the respondent, my lord. That, if your lordship may kindly see, we have worked out all those things. This provisional pension has been sanctioned and the papers have been forwarded to the Accountant General for my lord, for
Have they
payment.
filed any contempt?
No. What has happened, my lord, those two orders, the steps which we have taken, that has been challenged by the respondent in a writ petition. That is why I'm praying that let this matter come along with that writ petition, because an interim order is also, my lord, seems to be operating in that writ petition, my lord.
List along with?
My lord, 26812 of 2020. That's pending.
That's for the single judge.
Yes, madam. Yes, madam.
Then what's the point, sir?
My lord,
Then we'll simply dispose it off, saying all these pleas you can raise that writ petition. Your reply to that writ petition.
Lordship,
All right. It appears that pursuant to the order of the OAT, orders were issued by the appellant, which have been challenged separately by the respondent.
In
writ
WPC
petition
2681. In WPC 26812
26812 of
2020.
2020, which is stated to be pending before the learned single judge.
Yes.
You are there for him.
No.
In that view of the matter, permitting the appellant to raise all the pleas urged in the present appeal. In those proceedings, the present appeal is disposed of.
Item number 9.
May I please, your lordship? My lord, on behalf of Mr. Bibhu Prasad Tripathi, this matter relates to settlement of tenement in favor of respondent number 1. Identical matter has already been on board, my lord, on 26th April and 27th April. And my lord was pleased to pass
Where's
an
the
order.
order, sir?
My lord,
Where is the order?
I did not bring it, but I have gone through it, my lord.
That's very nice of you, sir. You have to give us at least writ petition number, copy of order, something you have to give us.
My lord, number I am giving. 550 writ appeal 558 of 2021.
You love to give us some homework.
My lord,
We are sitting idle.
I'm
doing
sorry,
nothing.
my lord. Actually, it was not uploaded, but when before coming to
Same
the
judges,
court only, I checked it.
let judges also do some work.
Oh.
You're sitting idle on the bench.
In the contempt matter, I am appearing. My lord, what happened in the court of my lord justice?
1 minute. What is the order? You want, sir? Should we also supply you a copy?
No, sorry.
It's already uploaded. Just for your information. You also do not have a copy, sir.
No, I am in contempt matter.
Show it. List along with. Is a notice. All the same thing. List on second. Whom are you appearing for, sir, in the contempt?
I am appearing for the respondent number 1, opposite party number 1, who is no more there also. And beloved, as the commissioner, he is changed. Now he has been changed. And beloved, now beloved, here what has happened, the basis of the order, beloved, other batch of cases, direction was given for settlement by the BMC.
One minute. You're for the appellant of the respondent?
He is for the
Appellant, my lord.
Ah.
He is for the appellant.
Aha.
So now what I want to apprise your lordships.
You're for whom?
I am for the in the content matter. In the content matter for the commissioner BMC. In person.
Both of you are BMC?
BMC.
Ah, only you're standing separately.
Ah, yes.
Ah, you don't like each other.
Oh, yes. No. What I assist you lordship further, because the settlement was directed in other 2 writ petition, commonly order was passed. Thereafter, these orders have been passed. But in that case, already that review have filed and review has been allowed. So that direction was diverted to the government to consider, not the BMC. So in view of this, well, at the first appeal, the writ appeal also can be disposed of in that line. So if your lordship,
you're not aware of all this.
Yes.
No, my lord.
That is the RBWPT number 145 and 246 of 2020 disposed upon 2/2/2023.
That also please take out the order. You don't have that order, no?
That order I had.
So you'll only have to take it out.
RBWPT number.
We agree with all of you, sir. Actually, we are starved for work. We have no work.
No, my lord.
We have to get out all copies of the orders. You will give us numbers. We will do the research work.
My lord,
we'll supply you copies of orders. Give us copies of the orders.
RBWPT number 145 and 246 of 2020 disposed upon 2/2/2020.
So any other matter you want copies of orders, come here. Actually, we have
yes,
no work.
That is right, lord.
We have no work. See, we have no work.
No, the difficulty is that because
we are idly sitting here, sir, without any work.
Because
so please give us whichever other matters also, whatever orders you want, you come here. We'll ask him to print it out.
Yes, right.
It's all right.
Yes. My lord, during Diamond Jubilee, your lordship, we are held up. We are held up.
Agree, we have no work. That is very nice of you.
My lord,
you know how many matters are listed today?
My lord, we are silent visitors.
No.
Having 40 years of practice,
you are very. You're generously agreeing. You're generously agreeing with us that we have no work. Do you know how many matters are listed today?
My lord, during holidays, my lord, we go outside to enjoy. And
do you know how many matters are listed today?
That is right.
What is right? Tell us how many matters are listed today.
My lord,
before this bench, how many matters? Before me, singly, how many matters? Tell me.
That is right, but this
what
side
is right?
But this side is
how
very
many
difficult.
Matters? You tell us how many matters.
Yes.
He says there's no need to interfere with the order and direction, disposal of so and so.
Yes. Well, there was a direction to the BMC directly to settle. Then the court realized that you need not interfere. Now it is to be to the government. It is directed. It was directed to the government. So that is why no contempt will be there. No also writ appeal need be decided further. Can be disposed of in that line.
All right. Just show me that order. That other writ appeal order. You also need copies, sir?
No, my lord. I will.
You're okay. No, we can take out copies for you also.
No, I will manage.
All right. Sorry, sir, to trouble you so much.
I'm grateful.
You will excuse us?
I am grateful to you, Lord. Not excusing.
Oh, I see. Very nice. Very nice. No, that other writ appeal. We were so free till you reminded us. I think till now he has not even understood what we are taking. That's all right. Just put down writ appeal 646. At the outset, counsel appearing for the appellant drew attention to writ appeal, the order passed by this court in writ appeal 558 of 2021, in which notice had been issued and the matter had been asked to be listed on 2nd August 2023. So, however, counsel appearing for the respondent in the conducted contempt petition 466 of 2020, which arises out of the order passed by the learned single judge on 18 March 2019 in writ petition civil 18168 of 2008 and writ petition civil 7597 of 2013 informed the court that by a subsequent order dated 2nd February 2023 in review petition number 145 of 2020, the same learned single judge was passed the impugned order in writ petition civil 14. So the impugned order in the first writ appeal is 14760 of 2017.
Yes, yes. This order also in the writ appeal is the similar order in respect of that cases.
Just before the sentence, you say a similar order has been passed in review petition number 246 of 2020, which arose out of a similar order passed by the learned single judge in writ petition civil 14760 of 2017, which order has been challenged in the writ appeal listed today, that is writ appeal 646 of 2021. Paragraph, the net effect of the order passed in the review petition is that the directions issued by the learned single judge have now been asked to be implemented by the Housing and Urban Development Department, Government of Orissa, and not by the BMC. Stop. Paragraph. It is accordingly submitted that the present writ appeals have, in view of the above developments, writ appeal has been, in view of the above development, rendered infructuous, and the contempt case also does not survive. Paragraph. Writ appeal 646 of 2021 and contempt case number 4566 of 2020 are accordingly disposed of in the above terms. Then we say, upon mentioning, take this separately. Writ appeal 558 of 2021 is taken on board. In view of the order passed today in writ appeal 646 of 2021, the present writ appeal is also disposed of in the same terms. The next date of 2nd August 2023 is cancelled. All right.
Well, another writ appeal was also there, 647 of 2021. A similar order has been passed.
Okay, that 647 of 2021 taken on board in view of the order passed today. Which is the next date in that?
2nd August.
The next date of 2nd August is cancelled.
Okay.
Item number 10.
DLR regulation 25th of September.
Item 11.
On behalf of Mr. L.K. Mahanti, infructuous.
All right. Counsel, the appellant states that the present appeal
copy may be served.
Has been rendered infructuous, disposed of as such.
Item number 12.
12 vigilance promotion matter 11th of May.
All right.
Item 13.
Rehabilitation assistance scheme 30th of August. 38.
Item number 14.
But in DLR regulation 25th of September.
All right. Item number 15.
May please, Your Lordship. My Lord, in fact, here in the before the Honorable Single Judge, the matter we appeared on 14/12/2018. The matter was listed on 12/4/2019. However, the name was not reflected, as a result of which the matter was dismissed. Subsequently, when steps for listing was taken, it was discovered that the matter has been dismissed and application for restoration was filed. I consider that there was delay. But after 2019, this COVID set in, and thereafter, this restoration application has been filed on 4/10/2021. Honorable Single Judge has been pleased to reject it, saying that there is delay. My prayer is this is a case of dismissal, and this is the bona fide that name was not reflected, for which reason it could not be noticed in the list.
871 days, sir.
My lord, your lordship will kindly consider the dates. 14/12/2018 we appeared. 12/4/2019 it was listed. The name was not reflected. But thereafter, when steps were taken for listing, when it was discovered, 4/10/2021 it was filed. By then, from April 2020, the COVID had set in, my lord. And during that COVID period, my lord, it was filed. So, your lordship, maybe there was somewhere around my lord, 1 year gap so far as the dismissal is concerned, because thereafter the COVID set in. And this is a case of dismissal. I pray, my lord, your lordship may kindly consider. And this is the bona fide. The name was not there. So therefore could not be noticed, my lord. Had it been a case of, my lord, other negligence, my lord, I would not have pleaded for lordship.
What's the main matter about?
The main matter is, my lord, relating to, my lord, dismissal, my lord, and he has challenged that in the writ petition.
No. Land rights to slum dwellers. What is this?
Item 15, your lordship is taking up. Item 15, your lordship.
Yeah. 981. Sorry, 1 minute.
Defense dismissal.
23119, right?
Mine. 23119.
Let me just see what the matter is about. Termination order.
Termination has been effected, ma'am.
Mr. Padi, you have any objection?
My lord?
Lordship may hear it. Lordship may hear it.
Or you say the writ appeal is directed against an order dated 22nd November 2021, passed by the Lord Single Judge, declining to condone in IA number 117 of 2021, in CMAPL 270 of 2021, declining to condone a delay of 871 days in filing the restoration application. Paragraph. It is explained in the writ appeal that the writ petition civil 23119 of 2010, filed by the appellant, was dismissed for non-prosecution on 12th April 2019. According to Mr. Mishra, learned counsel for the appellant, the name of the counsel of appellant was not reflected in the cause list on that date, and therefore the matter was missed out. Full stop. Paragraph. By the time it was realized that this fact was realized, the COVID-19 pandemic had set in, and the restoration application was filed on
4/10/2021.
4/10/2021. Full stop. He submits that, therefore, a substantial part of the delay of 871 days could be explained away on account of the COVID-19 pandemic. Paragraph. Considering that this is a matter involving the termination of the services of the appellant, the court is of the view that he must be given one more opportunity to pursue the writ petition, particularly when the pleadings were already completed in the said writ petition. Paragraph. Having heard learned counsel of the parties, the court sets aside the impugned order dated 22nd November 2021. Full stop. The delay in filing the restoration application will stand condoned, and the restoration application will also stand allowed by the order dated 12/4/2019 of the learned single judge, being hereby set aside. Full stop. The result of the above is that writ petition civil 23119 of 2010 will now stand restored to the file of the learned single judge in the roster bench, where it will be listed for directions on 24 July 2023. Full stop. Considering that it's a writ petition of 2010, and since pleadings are already completed, the present appellant will not seek any adjournment. Neither the present appellant nor the opposite parties will seek adjournment in the petition. The learned single judge is requested to dispose it of as expeditiously as possible.
I'm grateful, man.
The writ appeal is disposed of here.
Item number 16.
Lordship may mention along with me, Mr. D.K. Padi is appearing with me.
Yes, definitely. The writ appeal is dismissed as not raised.
Item 17.
My lord, 17 and 18, 8th of May, my lord. Sattapeta case.
All right.
Item number 19.
19, my lord, DLR regulation 25th of September.
All right.
Item 20.
My lord, item 20, I pray for 2 weeks time to comply the defects, my lord. My lord, the certified copy I have filed, but in a wrong year number, instead of 2016, in 2021, it was filed on, my lord, 10th of May 2022. And so far the power in the writ petition, my lord, I have power. My lord, I may be allowed to file a fresh Bokalatanma, or the my power in the writ petition may be read as a power in the writ appeal, my lord.
No.
Because
Counsel for the appellant wants time to file his Vakalatnama.
fresh
A
Bokalatanma.
last opportunity is granted to do so before the next date. 7th August.
My lord, since I've appeared in the writ appeal, may I pray my learned senior to serve a copy, my lord,
All right.
so that it can be disposed.
Item 21.
21, Sattapeta, 8th of May, my lord.
All right.
22.
22, 25th of September, DLR regulation.
Item 23.
20, same, my lord.
Item 24.
24, 25, Sattapeta, 8th May.
Right.
Item 26.
At 26, 27, permitted to withdraw with liberty to file review.
Review. All right.
Item 28.
My lords, item number 28, your lordship, the IA, the limitation petition is not before your lordship. And what I pray is, there's a connected matter, writ appeal number 1025 of 2021 of this relating to the same respondent. Your lordship may kindly call it as per your convenience along with that.
When is that coming up?
No, that has not come up yet. That will be coming up fresh before your lordship. That happens with the main one, my lords.
Or list tomorrow itself. List along with 1025 2021 tomorrow. Right.
1025, yes, my lords. I'm sorry. Yes, my lords.
Item 29.
None appears dismissed.
Item number 30.
Item 30 and 31, Sattapeta, 8th May.
Right.
Item 32.
32, regulation matter, my lord, 25th of September.
Right.
Item 33.
My lord, 14th of September, my lord.
Right.
Item
34,
34.
same, my lord.
35.
35, 8th of May, my lord, Sattapeta case.
Item number 36.
My lord, 36, 37, my DLR regulation 25th of September.
Item 38.
38, 8th of May, my lord, Sattapeta case.
Item number 39.
May I please, my lord, here a fast state disposal without, my lord, calling upon counter and anything, your lordship has been pleased to deal with similar matters on many occasions. I beg to, with your lordship's kind permission, file 2 sets of orders passed in similar cases for your lordship's kind perusal.
It has gone back.
Yes, my lord. And exactly same order, your lordship has been
Just
pleased.
give him 1 set, sir.
I have given 2 sets to your lordship, to my friend also 1 set who is appearing now.
You pass a similar order, sir.
My lord, only one question is to be decided. Whether my appointment is illegal or irregular.
But I have not been given a chance. Your lordship, same order, your lordship has been pleased to quote in that. May I just draw your lordship's kind attention to place?
Sukanti Biswal.
But the first case itself, your lordship will see page 3. Page 2 of the order, your lordship has been pleased to quote the order.
Yes.
And in this case, the order is one and same, exact verbatim, your lordship will see.
Right.
And all these cases have been set aside and matter has been limited to provide me opportunity to file so cause and in fact, the case which has been referred to has no application to the present case. Now that is a case thing I have to urge for the Honorable Single Judge.
Same order. Only the dates have to change, no? The dates have to change.
My lord, the dates have to be changed. My lord, and the case number will be different. My lord, the WPC number. Page 77 is the impugned order. The verbatim is almost same. Hey.
You'll have to make those changes and give us, sir. Otherwise, it's confusing.
May I point out one? Here I have to give in a chance to for pleading. Because here there is also no pleading on the first day itself.
Oh,
That much I do.
all right. Which was the earlier order passed by us? It's the second round, right?
Yes, my lord. This is
In this case, my lord, on 23rd of March, your lordship was pleased to stay it and issued notice. Though my lord, the requisites noting it has been filed 1 day late, but my friend also, your lordship permitted me to serve copy. I have served on my friend who is appearing. Ma'am, may I just, your lordship wanted me to submit by putting the correct numbers, my lord?
No, no, it's all right.
Ma'am.
Say the present appeal is directed against an order dated 2nd December 2021, passed by the learned single judge. Allowing requisition civil 35932 of 2021. Filed by the respondent. In view of the judgment dated 9th September 2021 in writ petition civil 19951 of 2020. What has happened to that judgment?
Those petitions, your lordship has been pleased to fix state other cases, my lord.
The 9th September 2021 in writ petition civil 19951, which has been followed by the single judge.
That is a case which was challenged for reasonable court. Your lordship has been pleased to pass a judgment affirming it. But that case has no application. That was in respect of the government servants. That has got no application to the present case, my lord.
I see.
That has been, my lord, that is writ appeal number. I have the numbers, my lord, but I may be pardoned that I don't have a copy of your lordship's judgment. I'm extremely sorry for that, my lord, but it has been affirmed in writ appeal, my lord. That is writ appeal number 777 of 2021. It has been affirmed. I'm extremely sorry, my lord, and I.
Oh, Patibaba.
It has been uploaded, my lord.
Incidentally, the said order has been affirmed by this court by a judgment dated.
Writ appeal number 777 of 2021.
9th September 2020.
Number 777 of 2021. I am extremely sorry for the inconvenience, madam. Extremely sorry. I apologize.
Appeal number 777 of 2021, bracket State of Orissa versus Patita Pavan Datta Das. Counsel appearing for the appellant informs the court that the present case is not similar to the aforementioned case and stands on an entirely different footing. Right. As far as the present case is concerned, petition civil 35932 of 2021 was the second round of litigation involving the respondent, who is today represented by Mr. So-and-so, advocate. So in the earlier round, the respondent had filed with petition civil 12043 of 2020, which came to be allowed by the London single judge on the very first day by an order dated 15th May 2020. Asking the present appellant to take a decision on his plea for regularization of his services. Full stop. Pursuant to the above order, the appellant passed an order on 25th September 2020 declining to give the respondent the RACP benefit with effect from 19th September 1991. This led to the respondent filing contempt case number 3550 of 2020, which was disposed of by the single judge on 4th September 2020, directing the appellant to comply with the judgment dated 15th May 2020. In writ petition civil 12043 of 2020. Paragraph. For the second time, respondent number 1 filed WP civil number 35932 of 2021. Challenging the order dated 25th September 2020. And making the same prayer for regularization of the services. So this second writ petition has been disposed of by the impugned order dated 2nd December 2021 by the learned single judge on the very first day. Without an opportunity to the present appellant to even file a counter affidavit in the said writ petition. And by following the order of the learned single judge in writ petition civil 19951 of 2020, bracket Patita Pavan Datta Das versus State of Orissa, which according to the appellant had no application to the facts of the present case. Paragraph. On the short ground that the impugned order was passed on the very first day, without an opportunity for the appellant to file even a reply, it is hereby set aside. And writ petition civil number 35932 of 2021 is restored to the file of the learned single judge, where it, in the roster bench, where it will be listed for directions on 14th August 2023. The appellant will file its parawise reply to the said writ petition on or before 1st August. And the respondent number 1, writ petitioner, will file rejoinder, if any, thereto on or before 14th August 2023. So it is made clear that neither party will be allowed any further time for the above purposes. The learned single judge is requested to proceed with the hearing of the writ petitioner matters and dispose it off as expeditiously as possible. Till then, status quo shall be maintained by the party.
Obligement. Obligement.
Item number 40.
Mr. Behra is ill. He is bedridden, another date may fix. Sorry, what is it, sir? Conducting counsel under there, he is ill. Let's see what the matter is. What's the delay? You don't have the paper book, sir? Do you have the paper book? No. You just came into the court. Casually. Paper, yes. You're taking a walk. Medical report is there. No need for paper book. Suppose I ask you some question about the case, you will not know. No. Only task is to walk into Chief Justice Court, ask for adjournment. Nothing else. How many years of practice? 30 years.
The Honorable Single Judge has remitted back the matter to the Consultation Commissioner, and there is a direction that they will appear before the Commissioner on a particular date, 16th May 2022, along with so it must have been disposed of, I think. Lordship may see page.
And we gave them time for defect curing.
Page 91 of the appeal memo, impugned order at page 4.
Counsel the appellant stated to be unwell. List on 1st August.
Item 41.
41, my lord, on behalf of Advocate Manoj Kumar Barik, 2 weeks time may be given for removal of defects.
Matter of 2022, sir. Already given, sir. On 22nd March, we gave time for curing defects. You can't give more time, sir. On 22nd March 2023, time was already granted for curing defects. Till date, defects have not been cured. The court does not propose to give any further time for this purpose. The writ appeal is dismissed.
Item 42.
Here, my lord, I have removed the defect on 27/4/2023, my lord. I have filed, my lord. Here is the case. That is a, my lord, a reversing order, my lord. The PLA has allowed the claim of the appellant, and the Lord Single Judge has reversed it on the ground that there is a suppression of material fact, my lord. The PLA has held, my lord, the LIC has not produced any document relating to suppression of material facts. The Lord Single Judge has held that while filling of the proposal form, the appellant, the deceased, have not disclosed the existing policies. But that was not in the proposal form. Only thing, my lord, in place of no, he has given a tick mark, my lord. That there is no existing policy. That's why, my lord, the Lord single judge reversed the order, my lord. Your lordship will kindly see page 21, paragraph 5, my lord.
No, but the point is that you already had subscribed to other policies, correct?
My lord, in the proposal form, there is a clause whether you have any previous policy or not, my lord. Instead of putting no, my lord, he has given a tick mark. There is no other materials to disclose that he has an existing policy, my lord.
Oh, you don't have other existing policies?
No. He has existing policies. But in the proposal form, my lord, there is no mention to disclose the entire policies which he had, my lord.
No, but the fact whether you have or not is important. In asking you whether you have, you seem to say, no, I do not have.
Only thing, my lord, in place of no, he has given a tick mark. The PLA has examined that and held that this is not amount to suppression of material fact.
No, how will it not be? When you tick the box saying no, anybody reading it would think you have no previous policy.
My lord, I have taken a ground, my lord. The proposal form have been filled up by them, my lord. Only I have given a signature. And second thing, my lord, that they have also, my lord, they have to examine whether I have any existing policy or not. They have to give a.
See that ubireme fide, that's the principle for insurance policies. That you have to be you have to disclose the complete facts in your.
That is not in the form, my lord. That is not in the form. To disclose the entire fact. Only thing, my lord, they have in the form, they have only mentioned whether you have any existing policy.
That is a material fact.
That is instead of, my lord, no, she has given a tick mark.
No, you have given a tick mark saying no.
No.
Seven other policies. All right. You say the challenge in the present appeal is to an order dated 22nd March 2022, passed by the London single judge, allowing writ petition civil 8555 of 2014 filed by the respondent insurance company. Thereby setting aside an award dated 16th December 2013 made by the Permanent Lok Adalat (PLA). Paragraph. The reason why respondent insurance company challenged the aforementioned award was about the appellant herein.
I am not the policy holder, my lord. I am the nominee of the policy.
That is the husband, the late husband of the.
No, my lord. The parents, the parent.
Okay.
The mother of the appellant, my lord.
Or the late mother of the appellant herein had not disclosed the fact of 7 other policies having been already taken. The PLA appears to place the burden of showing that the deceased had previous policies on respondent one company.
Other companies may not respond.
No. The one who's repudiating is respondent number 1.
Other companies, my lord. Other insurance companies.
No. But the person who's questioning that is respondent number 1 company.
Yes, my lord.
Further, the PLA appears to have come to the conclusion that in response to the item 17 in the proposal form, where the disease was to indicate details of the other policies held with other insurance companies, she had ticked the word single quotes no. Full stop. According to the PLA, this did not amount to suppression of a single quotes material fact. Unquote. The above fact is not disputed by counsel for the appellant, but she maintains that it was for the respondent one insurance company to elicit the details of the other policies held by the deceased, and that the appellant, who's a nominee, could not be expected to have those details. Paragraph. The learned single judge has rightly observed that the deceased, who was the policy holder, had indeed suppressed a material fact by answering single quotes no, when in fact she was aware of the other existing policies that she had taken. Full stop. The court is satisfied that the learned single judge has not committed any error in allowing the writ petition filed by the respondent one insurance company and setting aside the award of the DLA of the PLA. There is no merit in the present appeal.
My lord, the only thing, my lord, instead of mother, sister here.
Sister, all right. All right.
Item 43.
May I please, your lordship? The present appellant assailed the order of the Honorable Single Judge, your lordship, who dismissed the writ petition filed by the petitioner.
Defects not cured, sir.
Lordship, defects is only mobile numbers and state copy already filed. That is the defect, sir. The fact remains, your lordship, the question involved in this case, whether Sikkim tenant, after death of Sikkim tenant, the property will revert back to landlord or it will be succeeded by his legal heirs. The fact remains, the 1976-74, the property has been transferred to the present petitioner by the landlord. The Sikkim tenant died in the year 1955. The act came into force, amending act came into force in your lordship in the year 1976. So the transaction is before the act come into force in the 1976. But the Honorable Single Judge failed to appreciate this fact and dismissed the writ petition. And I have also relied upon a judgment of this honorable court where the court holds that the Sikkim tenancy right in absence of uses or customs will be revert back to landlord. That judgment also not dealt with by the Honorable Single Judge. This judgment may place only one.
Heritable and transferable.
Heritable. 76.
Transferable.
Where do you want to read?
Para 6, your lordship, para 6 of the judgment.
Yes.
ये 43 ना
Another judgment of same like your lordship of this honorable court. The fact remains the transaction of the year 1974 and act come into amending act in the Oiler Act, it came into force in the year 1976. So my respectable submission is when the transaction is the 74, my sell deed would not have been discarded or taking into consideration the amending.
Counsel the appellant seeks to rely upon the judgments in Budev Padhyani versus Brahmaradas 1973 1 CWR 878 and Udayanath Pradhan versus Daitri Marana. Volume 37. Cuttack Law Times 1148. To urge that the learned single judge ought to have allowed the prayer to set aside the orders dated 31st August 2000 of the Deputy Director of Consolidation and 4th June 2003 of the Commissioner of Consolidation. Negativing the prayer of the appellant that the property in question should revert to them once the Sikkim
tenants, Sikkim, SIKKI,
SAKMI,
double K.
SIKIMI. Died. Security tenants died. Say notice, Mr. Mahathi accepts notice for.
And if there is a private respondent, he is to contest.
Yes, yes.
Opposite partner 4, respondent.
Opposite party is 1 to 3. Notice to respond before returnable on the next date. List on 29th August.
Item 44.
My lord, on behalf of Mr. Vasudev Pujari, defect is Bhinama not filed. My lord, allow to me file the Bhinama tomorrow.
The impugned order is just one line. What happened to the other matter?
He should have annexed the order of that
12936.
Yes, 12396.
12396. Can you see? Reproduction civil 12396. Stays wrong. Yes. How big is it? How big is this? Is that other order?
Well, that order is not available at there. Let pass over the matter.
No, this, they say that this case is no way related to that disposed of case. That has to be examined. Because this impugned order is only one line, disposed of in terms
This
of the order.
party's own case, that is Bhavani Shankar Acharya versus Asit Baran
Yes.
Swine.
But here is appellant is Shashi Bhushan Das.
No, but Bhavani Shankar Acharya is a respondent before here.
Yes, madam.
Same. So this is the elections in that Orissa Ministerial Officers Association. Writ appeal number 1199 of 2022. Yeah, yes. First August. Defect speak your.
Item 45.
Item 45, one passable. Item 41 passable.
Item 46.
May I please? Lordship, there is an application for dispensing with certified copy.
Let's go to the main matter.
It's already filed.
All right, come to the main matter.
Yes, Your Lordship. Here, Your Lordship, I've come up in appeal against the order of a single judge, wherein the OJC was dismissed because of steps for issuance of fresh notice to the opposite party number 5 has not been taken in which.
Right.
And further adjournment was sought for, and after that the case was dismissed. Lordship, here opposite party number 5 is first of all is not a necessary party. He is the inquiring officer who has submitted the report in my favor, Your Lordship. And earlier also, while notices were from opposite party 2 to 4 were served, notice to opposite party number 5 returned unserved because that particular office was said to be abolished.
All right. So pointed all that out to the single judge. You did not take steps at all.
Yes, Your Lordship, it was. I bow down, Your Lordship. Steps were not taken.
You're not serious about the matter.
Pardon, Your Lordship.
See, on 3rd August 2017, nobody appeared. It was dismissed for non-prosecution. And then it's again restored.
My lordship, for the fault of the council, the appellant suffers, your lordship. The appellant is a driver, your lordship, who was, may I place the
1996 matter. How many chances to one way will give for that?
lordship, as a last chance, it may be heard on merits by the single judge.
It's a 1996.
I bow down, your lordship, but the appellant here, lordship, is completely without fault, your lordship. He absolutely, your lordship, may kindly see. He was a driver, your lordship. He has been punished.
You just have to see whether its orders are reasonable. The order passed under appeal. It's a reasonable one. That's what we have to see.
Lordship, it was for the fault of the council, your lordship. I just pray for it may be disposed of on merits, your lordship, as a last chance, your lordship.
See, it's also a stale matter. Because he was 46 in 1996. And now he'll be some 70 plus.
My lordship, but still the money is being recovered as that rupees 300. And the amount is being recovered from his salary, your lordship. From his pension, rather.
Right.
Lordship, may kindly grant me one chance, your lordship.
What?
The
See, from our point of view, we would simply have to see whether the impugned order of the learned single judge was justified or not. Nothing more.
Yes, your lordship, but the appellant has been not been negligent, your lordship.
What are you saying?
It was the council, your lordship.
No. The challenge in the present writ appeal is to an order dated 22nd August 2022 passed by the single judge dismissing OJC number 11843 of 1996, the following order, the policy order. It is apparent that the writ petition itself was dismissed for non-prosecution, later restored. Explain that despite orders in the writ petition, the appellant did not take steps to serve the opposite parties. On top of it, there was no appearance in behalf of the appellant on 3rd August 2017, leading to its dismissal for default. Thereafter, on 1st August 2022, after its restoration, it was again adjourned at the request of counsel to the appellant. The learned single judge has shown sufficient indulgence to the appellant to take steps to serve the opposite parties, public respondents. And despite the opportunities, the appellant failed to do so. Paragraph. Counsel for the appellant prayed that the appellant should not suffer for the mistake of his counsel. Stop. Nevertheless, it seemed that more than sufficient opportunity was granted to counsel for the appellant before the learned single judge to enable him to take steps as required. Stop. Despite those opportunities, the appellant defaulted in taking steps. So the court is unable to find any error having been committed with the single judge.
From 47.
May I pray, your lordship? Here, where the matter was when the matter was restored, then the notices were made sufficient before the means to the opposite party number 5 also. But after that, it was again held that notice was not sufficient and it was dismissed, your lordship.
Nobody appeared, I think, for opposite party number 5.
Nobody appeared, but it was restored on the ground that all the notices were sufficient to all the opposite parties.
No, but after it's restored, there must again be notice, na?
The restoration notice was made sufficient, your lordship.
We don't know that. It's all right. Yes.
Okay.
Item 47.
47 is, my lord, the impugn order relates to, my lord, recruitment of constable. And during that process, it was found that the respondent does not possess the minimum height. That is the entire issue, my lord. Lordship, may I kindly see page 89. The learned single judge has relied upon a judgment passed by this honorable court, basing upon which the writ has been disposed of. That judgment is a matter of challenge before Lordships, my lord. That is writ appeal number 157 of 2020. Lordships have kept it to 27th of September.
All right, list along with writ appeal number 157.
157 of 2020.
2020.
Yes, on 27th September 2023.
All right, on 27th.
Item 48.
Item, the Lordship has dismissed similar case.
In view of the judgment, yes, of this court dated 4th April 2023 in writ appeal number 1321 of 2022. Bracket State of Odisha versus Vijay Ketan Vidyadhar Sahu. The present writ appeal is dismissed.
Item 49.
Item 49, 1 week time may be allowed for remove the defect, madam.
That is Which item?
49.
At the request of counsel, please go. Second August, if it's procured in July.
Item 50.
Item 51 versus 14th September.
All right.
Item 51. 51.
My lord, on behalf of Mr. P.K. Ratha, kindly some time may be granted.
List on. July.
Yeah. Item 52.
Obligation.
52, 53, 54, 55, 56, Sartapada 8th May.
Item 57.
May I please, Your Lordship? On last Thursday, Lordship directed me to remove the defect. My defect has been removed on 27/4/2023. My
One more defect is there anyway. Yes, what's the matter about?
yes, my lord. My lord, the appellant here has challenged the judgment and order dated 31/2023 passed by the learned single judge. My lord, Lordship, for a moment, kindly have a glance at Annex 2. An advertisement was issued for recruitment of 7,540 posts of regular teacher in government secondary school. My lord, Lordship, page 28 is the annex, my lord, issued by the Odisha Staff Selection Commission. My lord, Lordship may kindly come to page 34. Page 34 of the advertisement, my lord.
Yes.
My lord, classical teacher Sanskrit. My lord, I am aggrieved by this, my lord. My lord, the qualification they have described is bachelor's degree with Sanskrit as one of the elective subject, optional /honors pass subject from a recognized university with minimum 50% of mark in aggregate or 45% for SC/ST, PWD, SCBC candidate. And Sikkha Shastri, a course prescribed by NCT from a recognized university, /institution, /BEd from NCT recognized institution. Here, my lord, here the qualification they have prescribed is contrary to the qualification prescribed in the NCT guidelines. For a moment, kindly have a glance at NCT, my lord. NCT guidelines, that is Annexure 4, page 50.
That whether it's equivalent or not is not the task of the court, sir.
My lord,
Equivalence is not the task of the court.
my lord, they have to follow the NCT guidelines. My lord, for a moment, kindly have a glance at page 55.
Yes.
It is very clear, my lord. Page 55, my lord. The applicability. You got it, my lord?
Yes.
These regulations shall be applicable for recruitment of teachers and physical education teachers in any recognized school imparting pre-primary, primary, upper primary, secondary or senior secondary or intermediate school or colleges imparting senior secondary education, my lord. This is applicable throughout the whole of India, my lord. And for a moment, kindly see the qualification they have prescribed. They have made two schedules. First schedule is for the teachers and second schedule is for the physical education teachers, PT. My lord, kindly have a glance at the same page 55, my lord. First schedule. The National Council for Teacher Education determination of minimum qualification for persons to be recruited at education district in primary, upper primary school, upper primary, secondary, senior secondary or intermediate school or college is regulated to 2014. And lordship, for a moment, that chart they have given, there is fourth last for secondary and high school, my lord, for class 9 and 10. Graduate / postgraduate from recognized university with at least 50% marks in either graduation or post-graduation, my lord. Here, my lord, what they have done, the Staff Selection Commission, my lord, the advertisement they have issued, they have omitted this postgraduate, my lord. Under Annexure 2. And now for a moment, my lord, kindly have a glance at the judgment passed by the Honorable Single Judge, my lord. Well, the judgment is page 109, my lord. Let's may come to page 118, my lord. Got it, my lord?
Yes.
Yes. Sorry, my lord, page 117, my lord. Just one page prior to. My lord, para 7. It is of relevance to note that National Council for Teachers Education in exercise of the power conferred under Clause DD of subsection 2 of Section 32 read with Section 12A of the National Council for Teacher Education Act 1993, 73 of 1993 and suppression of the National Council for Teacher Education determination of minimum qualification for recruitment of teachers in school regulation 2001 issued a notification on 12/11/2014. In the said notification, it has been provided except as respect things done or omitted to be done before such suppressions. The said regulation shall be applicable for the recruitment of teachers and physical education teachers in any recognized school imparting pre-primary, primary, upper primary, secondary or senior secondary or intermediate school or colleges imparting senior secondary education. The qualification for recruitment and promotion of teachers are prescribed under Rule 4. The first schedule, which has been published under sub-regulation 2 of Regulation 4, prescribe minimum academic and professional qualification for recruitment to the secondary / high school for class 9-10 under serial number 4. The said rule does not contain any qualification for the post of classical teacher. Therefore, the petitioner contention and the pleadings made in para 7 of the writ petition that the qualification prescribed by the Odisha Staff Selection Commission while issuing advertisement for the post of classical teacher Sanskrit is contrary to the National Council for Teacher Education. A regulation 2014 cannot be sustained in the eye of law since the regulation 2014 does not contain any qualification prescribed for the classical teachers Sanskrit. Here, my lord, the NCT has made two schedules, my lord, for first schedule and second schedule. In the first schedule, my lord, all category of teachers are coming under that. And classical teachers are also teachers, my lord. For a moment now, kindly have a glance at the NCT guidelines. What it says, my lord. Page 55. The first schedule, the National Council for Teacher Education, determination of minimum qualification for the persons to be recruited as educational teachers in pre-primary, upper primary, secondary, senior secondary, or intermediate school or college regulation 2014. This is applicable for the teachers. And second schedule, it is applicable for only PD. There is no necessity of prescribing other separate qualification for classical teachers, Sanskrit, Hindi teachers, or other category of teachers, because in that teachers column, all the teachers are coming under that, my lord. There is, my lord, for a moment, kindly appreciate, my lord.
Yes.
That first schedule, my lord, of that NCT guidelines.
Yes.
Page 55. The National Council for Teacher Education, determination of minimum qualification for persons to be recruited as education teachers, my lord.
You are a classical teacher.
Yes, my lord. Classical teacher is also coming under that, my lord. Otherwise, they would have made a separate guidelines or separate qualification for the classical or Hindi teachers. Here, my lord, kindly see the second schedule, my lord, page 56. The next page, my lord. The National Council for Teacher Education, determination of minimum qualification for persons to be recruited as physical education teachers in primary, upper primary, senior secondary, or intermediate school or college, regulation 2014. My lord, can they say, my lord? My lord, can they say that these classical teachers are not coming under this first schedule just because it is not there? It is not there because all category of teachers are coming under the teachers category.
Why have a schedule at all then?
My lord,
if all teachers are covered,
yes, my lord,
there's no need for schedule.
That is there reflected, my lord, as education teachers, my lord.
No. What's the meaning of a schedule? Schedule means only those teachers in the schedule be governed by the regulations.
Yes, my lord.
Classical teachers is not there.
My lord, classical teachers are there, my lord. Classical teachers may not be reflected in that first schedule. That particularly that is not reflected, but all category of teachers, my lord, it is for teachers. They are also teachers, my lord. And for a moment, kindly have a glance at another one, page 128. Why the post of classical teachers has been designated as a TGT teachers, my lord. 128, page 128, my lord. Kindly have a glance at page 125, Annexure 8. Government of Odisha School and Mass Education Department, dated 5/9/11. That is Annexure 8, my lord. And the relevant portion is page 128, my lord. Upgradation of the existing post of classical teachers. If, my lord, they say that the classical teachers are not coming in that first schedule. Only 10 graduate teachers are coming, my lord. Even that is also accepted, my lord. I am a 10 graduate teacher. Classical teacher post is also a 10 graduate post, my lord. Kindly have a glance at page 128. Consequent upon fixation of revised common qualification as mentioned in para 1, the post of classical teachers in government fully aided and block grant high school upgraded to the status with scale of pay at par with 10 graduate teachers vis-a-vis Hindi teachers of high school, my lord.
Come to para 10 for the impugned order.
Para 10, my lord, impugned order, my lord. Yes, my lord. Moreover,
please.
Moreover, on assessment of the comparative merit of this case, the court finds that by suppressing the resolution dated 11/11/2022 and 11/18/11/2020, this petitioner wants to take advantage of the resolution dated 5/9/2011. But I have never suppressed, my lord. Why I showed that, my lord, resolution? I showed that resolution before the learned single judge because, my lord, the post of the classical teacher has been upgraded. Here, my lord, they say that by suppressing resolution 11/11/2022, that I have annexed over here, my lord. For a moment, kindly have a glance at page 133.
No, come to even para 9. So now you have a separate qualification.
My lord,
classical teachers. Para 9.
Para 9 of the impugned order, my lord. Apart from the above, now the resolution dated 11/11/22 for recruitment of teachers in government secondary school has come into force. In the said resolution, the minimum academic and professional qualification for the post of classical teachers has been prescribed. Therefore, referring to such qualification, if the advertisement dated, I think, under Annexure 2 has been issued for recruitment of teachers, including classical teachers, the court is not inclined to Lordship may come to that resolution, my lord. They have here the learned single judges dealt with 11/11/2022, my lord.
Yeah.
That is page 137.
Yes.
Recruitment of teachers in government secondary schools, my lord.
Yes.
My lord, this is, my lord, issued by the Government of Odisha Department of School and Mass Education Department. My lord, when there is a conflict between the State Act and the Central Act, my lord, Central Act will prevail. And here, my lord, the status of this classical teacher has not been changed, my lord. Only the qualification has been changed. The status remains the same. The status of the classical teachers as TGT teachers doesn't change at all, my lord. Only the qualification has been changed here, my lord. My lord, I am posing a question to myself whether a classical teacher is coming under the teachers category or not. If they are not coming under the teachers category, my lord, then NCT would have made another schedule.
All right. The argument of learned comes for the appellant is that classical teachers should also be deemed to be covered by the 2014 regulation.
Yes, my lord.
Notwithstanding that the said post does not figure as such in the schedule to the regulations. Full stop. He states that there was no suppression of any material fact as held by the learned single judge. He said notice returnable. 31st August.
Well, I pray, my lord, the examination has not started, my lord.
No.
So I may be allowed to, my lord, I may be allowed to appear in the examination. If I will not appear in the examination, the matter will become infructuous, my lord.
So this anyway it must have become infructuous.
No, my lord,
My
the examination has not taken place. My lord, examination will take place in July, my lord. So I pray, my lord, I may be allowed.
How do you know that? How do you know that? Who told you that July the exam is going
Yes, my lord, my lordship may act my learned
okay, then take off that
instruction
thing.
by
Mr. Kunti appearing for the school and mass education.
My lord.
Department states that he needs to take instructions on when the examination for which post is this?
Sanskrit teachers. Pursuant to advertisement to Annex 2, my lord. Pursuant to advertisement dated 23/11/2022.
When the exam for recruitment of Sanskrit teachers, schools, is likely to be held. You have done the opening list on 21st June.
21st June.
June.
Deeply obliged, my lord.
Item 58.
None of this exists. Oh, 58 is state.
58 my old pension 25th September.
Right.
59 also same 25th September.
Right.
60.
60 my 14th September work charge.
Item 61.
61 my data entry operator regulation 14th July.
88. Outsourcing that 88 minutes.
All right.
Item 62.
62 rehabilitation 30th August.
Item 63.
DLR regulation 25th September.
Item 64.
64, there's a delay of 14 days, Your Lordship.
That's all right. Tell us what the matter is.
Yes, Your Lordship. The grounds on which the Honorable Single Judge has dismissed the matter, Your Lordship may kindly see relevant internal page 72. Page.
Yes.
7.2. Since the court from the materials available on record find that the managing committee of the school prior to appointing the petitioner has not obtained the required sanction, the petitioner though was appointed after 5/1 but he was not having the required training qualification at the time of his appointment. The very appointment of the petitioner as per the view is not legal and justified. Identical matter on the self-same ground was dismissed by the learned tribunal. The Lordship starting page 74, the relevant page is page 85. Which has been quashed by this honorable court and 127 persons, and Your Lordship has also recently in 6 cases.
Was this placed before the single judge?
My lord?
Was this order placed before the single judge?
Yes, Your Lordship. But that was not taken into consideration. 14 series I have also annexed, my lord, the hardening orders. 6 matters. Your Lordships are disposed of 3 matters, and honorable coordinate bench 3 matters. On the very self-same issue, the grounds the tribunal had dismissed the original application, but this honorable court was pleased to pause the original application or judgment and allow the writ application. All the orders reflected there in the Your Lordship's order have already enclosed in the writ appeal as well as the writ application.
What do you say? Who's for the other side?
State.
It's not, this is coming for the first time.
My lord.
Oh. Okay, notice. Mr. Kunti accepts notice for opposite parties 1 to 3. Notice will now issue to respond before. Returnable on the next date. First August.
The delay may be condoned. I am filing the IA.
You file it, we'll see.
My lord.
Item 65.
65 and 66, but 14th of September, job contract.
Item 67.
Rehabilitation estimate 30th of September.
August.
38.
August. 38.
Yes.
Item 68.
May I please Your Lordship?
My lord, here my predicament was twofold.
No, defects.
Well, defects can be ignored.
Why?
Well, lord, if it is legibility. Copy has been served, I know.
No, there are two defects, my lord. So the single judge simply relegates you to the appellate authority.
My lord. My lord, my predicament was twofold. There is certain development also which has taken place. The first was that piecemeal adjudication and multiplicity of litigation. Your lordship is aware of the Karnataka State Road Transport Corporation case versus Srimati Lakshmi Devana in 2001 Supreme Court, wherein they have categorically decided that in a domestic inquiry under 11A, which was introduced, piecemeal adjudication was deprecated, and they said if the domestic inquiry is declared to be unfair, then management is to lead evidence. If the management is to lead evidence, they have to file a petition to that effect, and it both has to be decided simultaneously. Here, I stand on the same pedestal because in the CCA rules, there is a specific provision for appeal. Now, once a dismissed employee after so many years, he approaches the appellate authority. I had approached earlier this Reed Court tribunal. They said that you dispose of the representation within a period of 6 months. Thereafter, the representation was rejected. I came up here before your lordships. And now your lordship has directed again, said while the appellate authority order is an application on application of mine, have remanded the matter back to the authority without deciding the question of punishment. Second is, with regard to their other decisions, my lord, your lordship is aware of 1969 Supreme Court and also our 2000 Jagadamba Prasad Shukla versus State of UT 2007 SCC, wherein, my lords, the point is that in a service law, if a person is dismissed, is under suspension, and the subsistence allowance is also not paid to him during that period, then it amounts to no money, and the proceedings were quashed. Here, my lords, the financial factor is another consideration for which I have come up before your lordships. But the development is that during the pendency of this appeal, he had fixed a hearing on 29th, and this person is a cancer patient. He has not properly propounded his case before the RDC. So because your lordship knows that question of punishment, whether it is strikingly disproportionate or shockingly disproportionate, your lordship has the power, can entertain it on only that. But so far as the appellate authority is concerned, he has a wide power. He can convert change the punishment from dismissal to also termination, so that he can get his pensionary benefits. That is one aspect which can be taken into consideration by the appellate authority. So what I am giving a suggestion, my lords, this portion which has not been decided, I may be reheard, a date may be fixed, and he may go into the issue of punishment. Because here, what is the issue? Issue is, my lord,
it's coming up for the first time. Who's for the other side?
Copy not served. State petty.
Copy serve is. I'll launch for a copy.
There are defects. That's why I pointed out, I think.
No, I'll give a copy. I'll provide a copy. Your lordship may take it up after lunch. If that is that, I'll ask my clerk. He had served the copy.
But he'll have to take instructions.
Yes, I'll take you serve my copy and your lordship may fix it to next
copy of the appeal be served on Mr. Khuntia, learned additional government advocate. List on 22nd June.
Well, in between, he may pass a final order as per the direction of this honorable court. So that.
All right. In the meanwhile, proceedings before the
RDC.
RDC will continue, but no final order shall be passed.
Well, much obliged.
Item 69.
69 mark DLR mark 25th September.
No, my lord, I have already appeared. No, my appearance has not become. It is not a DLR matter, my lord. Because it is because the class 4 employee is continuing 1997. And only the Honorable Single Judge has passed for regularization of his service. And in the meantime, 25 years are already passed. It is separate from the DLR, my lord. It is not similar.
What was his status?
So now he is continuing because the class 4 employee and only he crossed the age of 54, 55.
Don't dispense with this also. What is this defect 7 and 9 not removed?
7 and
you say a complete set of papers be served upon counsel appearing for the respondent.
Delay of 5 months, my lord. That is
that's COVID, sir. So it's all condoned. 69, right? He'll accept notice for who?
Yes.
No, respond number 1. What about 2? Soil conservation, director soil conservation.
2, my 2, 3, my only one opposite party, my respond to one respond.
Oh, the others are joint appellants. All right. He accepts notice for the respondent. Complete set of the papers be served on him. Is that
No control.
just set down for final hearing of. August.
Item number 70.
70 mal job contract 14th September.
71.
71 rehabilitation of 30th August, man.
Item 72.
The job contract 14th September.
Yes.
Item 73.
73 promotion during pendency of vigilance case 11th May, man.
74.
74 mal DLF 25th September.
Item 75.
75 for the one pass.
Sorry?
One passable.
All right.
76.
76 my rehabilitation assistance scheme. 30th August.
Item number 77.
77 mal voucher 14th September.
78.
Well, I may pardon item 75 voucher 14th September. 75.
75 is it? All right.
Item 78.
78. Input order is at annex 1 page 19 mile. It starts from page 20 mile. Operative portion will also turn to page 30.
This is 79, right?
78.
This is the case, my lord. There, Honorable Single Judge has filed an order without taking into account the earlier order passed in Annexure 2, my lord. In that Annexure 2, Honorable Single Judge has directed they cannot claim regulation. Their claim for regulation has been rejected, my lord. You can find it from page.
No, this is not similar to any other batch.
No, 4 matters are there. What has happened? The batch of that association has filed, they have lost their case. So in individual capacity has filed the case. No, rules.
All right. 2nd August. There should be a stay. You're asking for a stay, right?
Yes, my lord, I was.
Defects you cured.
79.
70 job contract 14th September.
Actually, in 79, there's no defects. This is what we call now
79.
14th September. 70.
And even the earlier one, there's no defects. All right.
Item number 80.
80 work charge employee. That 14th September.
81.
Page 19 is the input order.
No, this again is without any reference to any other case.
Yes, no, this is the first time it is coming. This is my lord. What has happened, my lord? This is a employee of Gram Panchayat.
No, what happened in the connected writ petition?
That writ petition, that reference has been at 16838 of 2009. That has no connection with this case, my lord. Because
it is stated that WPC 16838 of 2009 is very different from the case on hand, and therefore the order passed therein will not apply. See, notice returnable. 14th August. Notice on this stay also. There's no contempt, nothing.
Item number 82.
About 82 to 90.
My lord, 14th September, job contract.
All right.
Item 91,
And 91 also job contract 14th September.
92,
92 DLR 25th September.
item 93,
Job contract 14th September.
item 94,
94 also about 14th September.
Yes.
item 95, item number 95,
Private office.
Password.
item 96,
96, 97, my lord, 98, 14th September, job contract.
All right.
99.
item 99,
My 99 the last may call this matter tomorrow. My lord.
All right.
item number 100,
100 and 101, 14th September, work charge. My lord.
for admission item 102,
Your Lordship's order dated 1st of March 23. State was directed to file an affidavit as to how many NAT labs can be commenced.
Yes, we have filed the affidavit.
You filed it?
Yes.
Oh,
Today we have filed the hard copy.
you have a copy of this?
Just they have served me now.
You want to examine it?
Just they have.
You just examine it. An affidavit has today been handed over in court. An affidavit of the Commissioner cum Secretary to the Government Health and Family Welfare Department has today been handed over in court. Mr. Agrawal, the learned amicus curiae will examine. That is request list on 21st June.
yes, sir. item 103,
May I please, your lordship, my lord, first of all, I beg apology for my lord defect that skipped from my mind and I could not remove it. And the other parties, my lord, the state and the central union government was directed to file counter in this case, my lord.
But defects are not pure at all. What's the matter about?
My lord, here, my lord, without declaration of the sanctuary, the notification has been made and the villagers have
Why
supplied.
was reply not filed, Mr. Paddy? Mr. Paddy? Where is he? Last time it took time.
State has also not filed the.
We will also file.
Last opportunity both to the Union of India and the state government to file the respective replies within 8 weeks. So joined up for the next day. Defects also be cured by the API list.
My lord, calling this matter.
Second August.
Obligement.
item 104,
May I please, my lord?
Okay.
Yeah, my lord, may kindly see the order dated 2012-2022. That is order number 16. And if my lord may kindly see paragraph 1, 2, and 3, wherein the court clearly said that the social audit should be videographed and uploaded for all 4 schemes. In paragraph 3, the schemes have been mentioned of that order. First is midday meal. Second is integrated child development scheme. Third is maternity benefit program. And other scheme for implementation of so and so.
Some affidavit was to be filed, right?
Yes.
Yes, my lord. I have filed affidavit. Lordship, may kindly see my affidavit filed by the Special Secretary to the Government, Food, Civil Supplies and Consumer Welfare
What's the
Department.
date of the affidavit? Is it after 18th April?
It's on 28th 4/2023, my lord.
28th April. Wait. Where is it? When did you file it, sir? Have you got a copy?
E-filing is being done. I have solved him a copy, my lord.
We haven't got it.
Yeah, I have received a copy. Now only he gave it 5 minutes back.
So you want to examine it?
But I have seen it, my lord. If that affidavit is seen,
I'll give, my lord.
they are still stuck with the whole thing. The schemes are, my lord, if that affidavit is seen.
Two affidavits have not come. One from the School and Mass Education Department. The second has not come from the Women and Child Development Department, my lord.
Now, if the court takes up page 10 of that affidavit.
No, let me place as per your my lord Lord and amicus curiae's observations. Lords may kindly come to para 3. Paragraph 3 of my affidavit, my lord. May I place, my lord?
Yes, please.
That with regard to the observations contained in para 3, 4, and 5 of the notes submitted by the Lord and amicus curiae in order number 19/4/2023 passed by the Honorable High Court of Orissa, it is humbly submitted that as far as the Food Supplies and Consumer Welfare Department is concerned, social audit on the functioning of the fair price shops and targeted public distribution system.
What is the outcome of that audit? What you are enclosing,
my lord,
is a document regarding. Oh, in that document you've set up.
Yes, my lord.
Social audit plan, social audit conducted.
Well,
no. The question is what came of the audit? No.
Yes, that is one that has not been done.
That's the main thing, sir.
And what they are doing, they are uploading 2-minute clips in their website of some social audits. Like the VC streaming, it has to be the entire thing.
But the idea is not whether you have simply conducted it. That's one part. What have you found? What are the corrective steps to be taken if you have found
consequential actions to be taken?
Oh no! First of all, what are the findings? Audit will have certain findings.
With regard to this, Lords may kindly take this only this department. Let the department first file, my lord. What is the
you say of the 3 departments? Only the Food Supplies and Consumer Welfare Department has filed an compliance affidavit in terms of the order dated 18th April 2023 filed by passed by this court. Copy of the said affidavit, which is handed over in court today, has been provided to learned amicus curiae, who points out that while the affidavit states as a fact that social audit has been conducted, in 6773 Gram Panchayats of 30 districts for the TPDS and FPS scheme, 1298 Gram Panchayats as regards the ICDS and Mamata schemes for 2020-21 and 1759 Gram Panchayats for those schemes in 2022-23. The findings in the said audits and the corrective action taken on such findings, if required, are not set out in the affidavit.
May I wanted to draw my lord's attention. My friend interrupted. Page 10 of that affidavit may be seen. Page 10 onwards, they are still stuck with the idea that it has to be only for 2 schemes. Page 10, my lord may see.
What is MDM scheme?
Midday meal.
Midday meal scheme, my lord.
That is no authorization there. Then my lord may see the next page.
No. So let the SME department.
My lord may kindly see.
SME department called for the, my lord, also affidavit from them.
OSAT is the organization they have chosen who will conduct social audit for all 4 schemes. Now, if my lord would see page 11, next page, what they write to OSAT, it's only vis-a-vis TPDS and fair price. So far as the other 2 schemes, they are still not writing to them. So why will they conduct? So they are still stuck that we will only do it for the fair price shops. For others, we won't do it. The letters, my lord, page 11, page 12, all of them don't mention all 4 schemes. So they are virtually, my lords, sitting over the court's orders in this manner. Page 11, 12, everywhere, all 4 schemes have not been listed out. And these are all after repeated notes of mine saying that you are not converging all 4 schemes. These are their own letters pursuant to the orders.
All right, that apart, it is pointed out by the amicus curiae that the correspondence enclosed with the affidavit only refers to social audit being conducted in respect of 2 schemes, namely the TPDS and FPS under the NFSA and the ICDS and Mamata schemes. We'll stop. As regards the midday meal scheme, the affidavit says that no authorization has been given by the School and Mass Education Department, bracket SME department. And which is the 4th scheme?
4 of them are there, no? TPDS, ICDS, Mamta, and MDM.
No, but then 3 they are they are holding audit for 3 of them.
3. Next page 11. Page 11.
Page 11.
Page 11. This is to OSAT, the agency which will conduct the audit. Approval of detailed projects so and so for conducting social audit on functioning of fair price shops, TPDS. Then others is all other schemes under NFSA, including so and so. So they have not specifically mentioned the other 2 schemes.
No, that.
Then next page, my lord, may kindly see. Videography of social audit meetings of fair price shops. So page 12 is more important. Like, so as we go ahead,
the social audit be conducted for the TPDS and for the ICDS, Mamata and MDM schemes. Paragraph. Mr. Tripathi, learned additional government advocate, state assures the court that the affidavits of the remaining 2 departments, that is the SME department and the Women and Child Development Department, will be filed positively before the next date. 1 week prior to the next date with copies to the learned amicus curiae. Paragraph. The court would like to reiterate what it has already noticed in its already stated in its order dated 20th December.
20th December 2022,
namely that the social audit must happen the social audit entrusted to the Orissa Society for Social Audit, Accountability and Transparency, bracket was SAT, under the Panchayati Raj and Drinking Water Department, has to be of all the 4 schemes. That is all the 4 schemes, that is the Targeted Public Distribution System, bracket TPDS, the midday meal scheme, the integrated child development scheme, and the maternity benefit program. Paragraph. The court expects that the affidavits of the other 2 departments, that is the SME department and the Women and Child Development Department, will provide details of the social audit of the above 3 schemes, which falls obviously within their jurisdictions. Paragraph. The court would like the OSAT to place before the court the actual findings of the social audit in respect of all the 4 schemes and the corrective action being taken in regards their availability and reach. Full stop. You take a chance on 11th July.
Oblace lots.
Item number 105.
Right, please, your lords.
So in this matter, my lords, we have for respondent number 4, we are filing the counter, my lords. And the last occasion, your lordship had directed me to take notice for respondent number 1 and 2. I pray for 2 weeks time to file counter for respondent number 1 and 2. Opposite party number 1 and 2.
Counsel appearing for the Animal Welfare Board of India states that he has already filed an wakalatnama on their behalf. He states he will be filing wakalatnama for opposite parties 1 and 2.
Yes, my lords.
As well. He undertakes to file a reply on behalf of them. On their behalf. On their behalf. On or before 26 June 2023. And rejoinder thereto, if any, be filed for the next date.
Grateful. Opposite party number 4, we are filing today, my lords. For opposite party number 4, we are filing today.
What? The affidavit?
Yes.
He states that the affidavit on behalf of opposite party number 4 is being filed today. All right.
I'm obliged.
List on. That 1st August.
Grateful, your lords.
Item 106.
May it please your lordships. My lords, your lordship issued the notice on 4/1/2023, fixing the date to today, and the appeal lies from the judgment of this honorable court. I have filed the requisites, I think.
Sir.
Beg your pardon?
Notice, has it been served?
Yes, yes. Notice I have filed the requisites, my lords.
No,
Lordship may see the track
one
record.
thing, service is another. Okay, who's respondent 3 is the added respondent. The electricity company is the added respondent, sir.
Beg your pardon, my lords?
3 and 4 are to be served.
I have already filed a requisites, my lords. I am not, I cannot say whether, but if your lordship,
Newly added respondent.
I have complied the direction of this.
TPODL.
TPCODL.
TPNODL.
This is standing counsel who appears on his behalf, sir.
Mr.
Without
I
them,
think Sarangi appears usually. Sarada Sarangi appears usually.
Despite service, none appears on behalf of TPNODL. Mr. Rai states that he will ascertain the standing counsel and serve a copy of the writ appeal on him. Dasti. Before the next day. July, sir. All right.
Item 107.
31st July, my lords, it will take some time. So what I pray, my lords, lordship may fix it at 2 p.m.
Let's see when let them appear on that day. Let us see. Nobody's appeared so far.
My lords.
107.
My lord, on behalf of Mr. Picarat, some days may be granted.
Mr. Rotha is out of station. He also requested me to
counsel for the appellant state to be in some personal difficulty.
Yes, I filed miscase for substitution and deletion of parties. Let's have the copy. I have not received the copy. They have not served on me.
Copies of the applications be served. You just put down 561 to 563. All those applications, in fact, IAS, you just say in all copies of the IAS we provided to counsel appearing for the respondent.
Interim order to be continued.
All right. Interim order to continue. Let's go on. August.
17th May.
August. 108.
On the first date of the hearing, the case has been disposed of without affording an opportunity to us. Notice, your lordship had issued notice, I had filed the requisites. The noting says it remains unserved, my lord. AD hasn't come back.
But there must be a tracking report. It's a registered speed post. There must be a tracking report. The registry is pledged to place and record the tracking report. Fresh notice by registered speed post. Returnable on the next date. The tracking report be placed on record on the next date.
Interim order.
List on. September. Interim order to continue.
Interim order to continue, my lord.
Item 109.
I may be pardoned, my lord. My lord, I am in virtual. Yes. 109.
Yes.
Lord, the whole issue involved with this, my lord, kind of a glance to the demand notice which was impugned before the single judge, my lord. Kind of a glance to page 13 of my brief writ appeal. The demand was issued against the petitioner claiming a royalty of 488 and a penalty of 480 on 29/9/2021 based on inquiry. Then let's say turn to page 18, my lord, the inquiry report, so-called inquiry report. My lord, the inquiry was conducted on 29/9/21 by 5 officers inspecting the site. And the same day, the demand.
My lord, in this case, your lordship has only sought for an instruction for me that whether 25% deposit which has been directed by the honorable single judge can be adjusted or waived. And so far as the merit of the case is concerned, if my learned senior will argue, then I have to file a counter, because in the honorable report, only that 25% your lordship can ask me what is my instruction, then your lordship can pass, whether it can be waived or not. I think my learned senior was pressing that much on the last date.
I agree. My submission is limited to that.
My learned senior may not go to the merit of the case.
So I'm not coming to the merit on the amount itself. Let's to appreciate the 29/9, the inquiry was conducted. On page 13, the demand was raised a royalty of 488 and penalty of 480. And my lord, this particular thing was taken note by my lord with a single judge in page 34, my lord. Kind of a glance to para 4 of the order of impugned. Let's have a kind glance to page 34 of my brief, that is the para 4 of the impugned order. Let's have got it.
No, but the point is, in the writ petition, was there no counter affidavit?
No counter affidavit. At the stage of admission,
at the stage of admission, the honorable court has remanded the matter that the collector will decide the matter and on the basis of the objection.
With all respect to Mr. Mahanti, let me complete the 2 words. Just have a kind glance. Let's see the London single judge, my lord, the points in the para 4. Considering the rival contents of the parties, this court and the perusal of the foundation in issuing such penalty notice on Annex 3, this court finds that the joint field inquiry is undertaken on the basis of a direction of loci and so on so date. In the entire reading of the inquiry report, this is important. This court nowhere finds involvement of the petitioner in such joint inquiry. In the other hand, the court finds the body undertaking joint inquiry involve complainant 1, Sarveshwar Vera. My lord, here there is no allegation against the petitioner in the finding of the inquiry report. And the demand notice comes, my lord, on the same date to the petitioner. My lord, my only submission that the 25%, my lord, the ordered direction for deposit, then, my lord, should have been to the amount of royalty that is calculated. Which, my lord, what has happened? The amount in totality that has been taken. 488 as the royalty demand and 488 as penalty. 2 things taken together, my lord, it comes to 977. So 25% of the amount means, my lord, the amount is the royalty that is demanded. And to that extent, I have my representation objection filed before the Tahsildar and the collector. And that, my lord, if directed at least to have it. So my submission, my lord, there is a cash deposit by the petitioner amounting around 57 lakhs available to the state government. So if this 488 is the royalty amount that is claimed in the so-called disputed notice, my lord, where the Honorable Court directed to have an opportunity before the collector for hearing that whether the demand is sustainable against me or not, that is to be taken. But so far the presentation of the appeal before the collector, which is pending, I am almost stuck up here. Because 488 is the total demand and penalty is 488. So the 25% deposit, my lord, has to be limited to 25% of the royalty demand. My lord, my service.
My lord, in the impugned order, there are two directions. First direction is the collector is to take note of the objection filed by the petitioner and pass a reasonable order on the demand notice and extra.
No, but that's conditional on his deposit.
That 25% condition. My instruction, what I have obtained instruction is that 25% condition has been imposed by the court. We have never. So your lordship,
it's our discretion.
It is your lordship. We cannot say anything.
All right. A limited prayer is made in the present appeal, which is directed against an order dated 10th May 2022, passed by the single judge, disposing of writ petition civil 11044 of 2022, in which the appellant had prayed for quashing a penalty notice dated 12th November 2021, issued by the Tahsildar Dharamshala to the appellant, raising a demand of rupees 977,99,730. Full stop. Paragraph. At the outset, it is pointed out that the aforementioned amount comprises a demand of rupees 488,99,865. That is towards royalty, and a 100% penalty equivalent to that sum. Stop. Mr. Manas Mahapatra, senior counsel, points out that the learned single judge has relegated the appellant to the remedy of an appeal before the collector against the above order of the Tahsildar. But
against the demand notice, against the demand notice.
Yeah, against the above demand notice of the Tahsildar, but has made it conditional upon the appellant depositing with the collector 25% of the amount total demand. Full stop. He submits that inasmuch as the learned single judge has noted that the demand was based on an inquiry made by the
committee member.
Collector.
By the committee member.
Right. By the committee is appearing from page 14 to 18, my lord. Deputy Director Mines, SPCB, Geologist, by a committee which was constituted pursuant to direction issued in a Lokayukta case number 1355 of 2020, without the involvement of the appellant in such inquiry. The appellant should not be asked to deposit 25% of the entire demand, bracket inclusive penalty, bracket, but only insofar as the single quotes royalty unquote component is concerned. Paragraph. Indeed, the court finds that the learned single judge prima facie found merit in the contention of the appellant, that the demand was based on a report of a joint field inquiry in which the appellant did not participate.
But petitioner has no involvement, the report says.
Except participate, not participate.
My lord may not record any observation because that will influence the collector while disposing.
while this is a prima facie finding, which will be examined by the collector in the appeal.
Yes.
There is, it appears that requiring the appellant to deposit 25% of the entire demand, inclusive of penalty, does appear to be a harsh condition. Consequently, the impugned order of the learned single judge is modified only to the extent of requiring the appellant to deposit within a period of 8 weeks.
That period is already expired.
No,
Your
within
lordship
a
may
period of
again
8
fix
weeks from
another
today.
date.
25% of the royalty amount demanded, bracket, exclusive of penalty, bracket, with the collector. So, this deposit will also be without prejudice to the rights and conditions of the parties.
Man, the amount is already available with the state around 57 lakhs deposited earlier.
So what does that work out to?
My lord, that I receipts have filed.
Yeah, in making such deposit, it will be open to the appellant to seek to adjust any amount already available with the state government. Right.
Okay.
The writ appeal is disposed of in the above terms.
Obliged. Order certificate.
May I please, Your Lordship?
They have been served a copy of an affidavit on 27/4. Of course,
which affidavit?
One a new
that has
IA
not come list IA number 2196 of 2023. And earlier he had also filed an application which I also required to file an objection. But if you call it some other day, I'll file objection.
IA number 2196 of 2023 has been handed over today in court on behalf of the appellant, in which he is praying for renewal of the registration of the trust. Sorry, in which it is prayed that appellant number 2 should be permitted to operate the bank account of the Neelachal Mission Trust for certain limited purposes. Mr. Buddhadev Rothriel and senior counsel appearing on behalf of
respondent number 4. I'm appearing for the respondent number 4.
Contesting respondent number 4.
My lordship,
Raised for some time to respond to the said affidavit.
Lordship, I am for the respondent number 5 on behalf of Mr. Dayanda Mahapatra. We received the interim application copy. We have to file a response.
A similar request is made by counsel appearing for respondent number 5. Paragraph reply to file within 4 weeks.
My lord, we are for respondent number 6.
All right, same. 5
on behalf of Peter.
My lord, I only pray, my lord, since it relates to a public, charitable, and educational trust, and because of these disputes,
the opening day list on 21st June. Right.
Interim order to continue, my lord.
Interim order to continue.
Obliged.
Passed over matter item number 45.
May I please, Your Lordship? In item 45, my lordship, there is an IA for condonation of delay. The delay is of 70 days.
All right.
The present appellant, who was working as an accountant in Kasturba Gandhi Balika Vidyalaya, which is under the control of Odisha Primary Education Program Authority, OPEPA in short, is assailing the order of Honorable Single Judge under Annexure 4, Your Lordship, at page number 19. If I will lead your Lordship in seriatim in the matter, pursuant to a resolution passed by the OP number 2, that is the OPEPA, by virtue of a resolution, I have been terminated for my service. All the male staffs who were working in the KGBB were removed, except the watchman. Now, this petitioner, he is working as an accountant, Your Lordship. An accountant, he is also staying in the outside the premises of the hostel, and he is working in his office, that's the administrative block, Your Lordship. Now, pursuant to my termination, my Lordship may kindly see page number 34, Annexure 6. Page 34, Your Lordship.
Now, what was that similar issue was raised in that other petition?
Yes, Your Lordship. The other male workers who were working in the KGB, that is cook, watchman, and other assistants.
Not you.
Not some of the accountants, not all the accountants, Your Lordship. My case is entirely different.
No, you're an individual or how many people are you?
In this appeal, I'm in a personal capacity, I'm filed, Your Lordship.
So you were not part of the earlier.
Yes, Your Lordship.
You were not.
My Lordship.
You were not party to that earlier writ petition.
No, Your Lordship. My writ application has been dismissed on the ground of the order passed in the earlier writ application, which was filed by the
counsel for the appellant states that the appellant was not party to writ petition civil 25385 of 2017 and batch, in which the learned single judge issued pass a judgment dated 21st December 2017, which was affirmed by the division bench. Full stop. In other words, it is submitted that the appellant has actually not been heard.
Lord,
in respect of his individual case.
I'm sorry, my lord. Lord, should I kindly see para 3. He had approached the honorable tribunal. The matter was thereafter transferred to this honorable court and renumbered. Renumbered as 2202 of 2014. That was heard. Lord, you may see Annexure 4, page 19. The averment he has taken in para 4. That was renumbered as 2202 of 2014.
My case has been dismissed along with these applications without giving an opportunity of hearing me. My case is that I'm an accountant. An accountant who is not.
So you're not, no. The point is, were you party to that writ petition or not? That batch?
No, I'm not. I was not party, Your Lordship.
To that whole batch.
202 is an individual case, Your Lordship. It was not a batch case.
So that you have to examine. Anyway, we're only noting the submission.
I have no hesitation. Lord, kindly see para 3. That the appellant approached the learned tribunal in OA number 2202/2014. He has challenged it. And that issue has been settled, my lord. Lord, see page 19. The same communication issued by the collector was regarding engagement of the, my lord, male staffs. Lord, kindly see page 19.
No, his engagement has been terminated. Here's a case of termination, sir.
It is not his case that he has been terminated. He's saying he has not been heard.
No, that termination is challenging.
My lord.
And his writ petition has not been considered, he says. You say notice, he accepts notice on behalf of the respondents. 1 to 4. Stop. Notice need not issue to pro forma respondents.
Yes, Your Lordship. They were party along with me in the writ petition. They don't want to join.
As there is no conflict of interest. Very good. List on. First you condone the delay, and then this list on. September.
I'm grateful, Your Lordship.
Item number 95. Item 95.
Then appears despite a passing. Dismissed or not dismissed. Over. After lunch.
Fresh admission item number 1, CRLMC 115 of 2020.
On a basis.
Item number 2,
Yeah, it is, Your Lordship. Matter of compromise between the parties, offense under section, my lord. My lord, 341, 294,
Where is the compromise thing?
Notice maybe issued, my lord, to the.
No. Where is the compromise?
My lord, I have heard that there was a compromise.
No, that's not good emphasis.
There was no annexation, but the matter was settled between the parties.
Whenever you get an affidavit, you file. The counsel for the petitioner seeks leave to withdraw the present petition with liberty to file an appropriate application in the event a compromise is reached between the parties. This post office withdrawn with liberty is made.
item number 3,
None appears.
4,
Same order.
item 5,
Same order.
item number 6,
Same order.
item number 7,
Same order.
item number 8.
May I please, Your Lordship? Here, my lord, I am the father. And the informed order is passed by the, my lord, additional district and session judge upon ex parte order, my lord, directing to grant maintenance. Your Lordship, may kindly see my wife expired due to heart stroke while she was residing in her father's house. By that time, my lord, my daughter was there. My lord, what has happened? I wanted, but there was no litigation, nothing else. We had very good relationship. Everything was okay. And my daughter was kept, my lord, forcibly they kept my daughter, the father-in-law's house kept my daughter. I wanted to bring back my daughter. Your Lordship, may kindly see, whenever I failed in my attempt to bring back my daughter, I filed one application before the Subdivisional Magistrate Puri, Your Lordship, under section 97 of CRPC. Your Lordship, may kindly see Annexure 3, the order is passed therein. At page 24, Your Lordship will get that order. Accordingly, Subdivisional Magistrate Puri, under section 97 of CRPC, I do hereby direct the second party members to hand over the minor girl child, Barsarani Sahu, to her father guardian, Ajay Kumar Sahu, forthwith. Without doing so, my lord, they have filed a revision here before the Sonal Court, which is pending. And without doing so, my lord, they claim maintenance and maintenance order is passed, ex parte. So I want, my lord, I pray before lordships that on criminal revision 497 of 2018, which is pending before the Sonal Court, challenging this order, that may be tagged with this and the matter.
Which order is challenged here and what does that matter?
That matter is, my lord, claiming maintenance. Maintenance award is awarded in my favor. Your Lordship, in favor of father. The child is forcibly kept by my father-in-law's house.
No. Maintenance order is passed in your favor.
No, against me. Against the favor of, my lord, my child who was kept forcibly.
I'm sorry, I'm a bit slow, sir.
My lord, I am sorry. I am sorry.
What is this petition is about maintenance, correct?
Maintenance.
Here you have been asked to pay your daughter how much?
7,000 per month, Your Lordship. Ex parte, Your Lordship. What is the ex parte order?
What do you do, sir?
But I am a my lord, ferry, that is blouse seller in the.
This is the only child you have?
Only child.
And this order, ex parte order, you challenged in revision.
My lord.
Revision you were heard fully.
My lord.
And the revision was dismissed.
My claim, my lord.
1 minute, sir.
Let
me just try and understand facts.
Yes.
Kindly be patient with me, sir.
Yes, Your Lord. I am sorry. I am sorry.
Which year was this ex parte order passed?
My lord. Ex parte order was passed, Your Lordship.
Date. Give me the date.
Annexure 4. The 2019, Your Lordship.
Was there a date, sir?
Date, my lord, I am sure. Fourteen 5/2019, Your Lordship.
Which is exactly 4 years ago.
My lord, I have challenged that order before the.
Very, very good, sir.
My lord.
What was the age of your daughter, sir, then?
Age of the daughter, by that time, Your Lordship, that 3 years.
And how much maintenance have you paid since then in the last 4 years?
But there is no relationship between my father-in-law's house with me because my daughter.
I didn't ask you what is your relationship. My question to you is This order was passed on 14th May 2019.
My lord.
How much maintenance after that date have you paid your daughter?
But I wanted to bring back my daughter because my daughter.
Sir, I'm not going to repeat the question again.
I have
not asking you
I
whether
have
you
not
brought
paid a
back,
single
didn't
pack.
bring back, whether you have relationship, no relationship. I'm simply asking you, after 14th May 2019, how much maintenance have you paid
No,
your
I have
daughter?
not paid a single maintenance because to whom I will pay. Because I wanted to bring back my daughter with me.
If you have taken upon yourself not to obey these orders, why are you challenging them?
No, my lord, my point is, my lord, I want to bring back my daughter.
Anyway, not prepared to obey these orders. Only if you are supposed to obey these orders, you have to seek to challenge.
My humble submission before Lordship.
Sir, please answer this question. Without complying with these orders for the last 4 years, why should we entertain your challenge?
But she is my daughter.
You answer as a lawyer now.
But she must be with me, your lordship. She must be with me.
What is the total amount due now to your daughter since that date?
Till that date, your lordship, it will be 2 lakhs, more than 2 lakhs.
My arithmetic is very poor. I hope your arithmetic is very good. How good is your arithmetic? I don't know. My arithmetic is actually very poor.
7,000 your lordship per month.
For 4 years.
4 years. More than 84,000 4 years. 3 lakhs some, my lord.
For 4 years, it becomes 3 lakhs.
My lord. 84,000 per annum, that 4 years it will be
3.4 lakhs.
3.224 lakhs to 6 lakhs. Like that.
Let's add 6% interest to it. 6% simple interest.
So your lordship may kindly visualize one thing.
No, I'm first visualizing this interest.
Permit
me to visualize it, sir. I'm visualizing the interest on the 3.4 lakhs at 6%.
Your lordship may visualize this. She is my daughter.
No, first we'll visualize this.
She is my daughter.
We'll first visualize this. How much money you've kept?
But I am unable to pay 7,000. Therefore, I have not paid.
So the easiest thing is.
My monthly.
1 minute, sir.
My monthly
nice logic.
My monthly income is not 7,000.
Mr. Mahapatra.
My lord.
Kindly understand what you're trying to argue.
My lord.
All right. So you have kept away from your minor daughter some 4.5 lakhs. If you add some 6% interest, right? Your only plea is you cannot pay.
But my income is 7,000 per month. It is not more than 7,000. I wanted to keep my daughter with me. She is my daughter. And my daughter is kept, my lord, forcibly by my parents, my father-in-law's house. For that, there was an existing order to hand over my daughter to me. I will maintain my daughter with me. And there is every possibility of misappropriation my funds if I will pay the money to my father-in-law's house. Moreover, my parents-in-law have passed away. There is nobody. Only my brother-in-law is now taking care of my child. And against whom, my lord, the order is passed, your lordship may kindly see. Page 51. It is, my lord, the next friend. It is directed through her guardian next friend to Srivas Chandra Sahu. He has passed away.
It's only in this state, sir. It is only in this state. I've also been a lawyer like you. It is only in this state I file a petition, I can keep quiet. And if I decide an order is wrong, 1 minute. If I decide as a lawyer, as a party, if I decide an order is wrong, I do not have to obey that order.
But
whenever a court asks, he says, why should I pay? That's a wrong order. I don't have to pay. You're so convinced this order is wrong, correct? You're absolutely convinced all these orders are wrong, or you're not?
Right.
You're so convinced. Why do you need a court? You don't need a court. You don't need a sessions court.
Great respect, I have to submit before lordship.
You don't need a high court. You don't need Supreme Court because anyway you're not going to obey.
With great respect, I have to submit before lordship. It is due to your lordship that matter is listed. Even if several memos have been filed by the advocate concerned, matter could not be listed.
So my deep apologies to you. So now because I listed this matter, you're being made to argue.
Mean I have not filed memos for listing of the matter.
Mr. Mahapatra is very agitated that the petition has been listed for hearing, although it was never listed in the last 4 years. he defiantly argues that he's under no obligation to comply with the orders that he has challenged, although those orders have not been stayed in the last 4 years. Full stop. According to him, once he is convinced that the impugned orders are wrong, he does not have to obey them, irrespective of the higher court not staying those orders.
No, that is my not submission. That was not my submission.
The court finds this kind of an attitude completely unacceptable. Full stop. Considering that this is an order, the order under challenge requires him to pay his 4.5-year-old daughter monthly maintenance, the court finds it even more unacceptable. Full stop. There is absolutely no merit in this petition whatsoever. It is dismissed with costs of rupees 30,000. Which you will not pay, I know that.
Your Lordship may kindly
cost
visualize
rupees
this.
30,000, which he will pay
I'm
in
sorry
addition
for-
to
I may
the arrears of maintenance to his minor daughter. Within a period of 4 weeks, a copy of this order will be sent to the concerned court to ensure that the impugned orders are enforced strictly in accordance with law.
Your Lordship may kindly see for a moment Annexure 3 for a moment.
I have done that, sir. Next matter. Call out next.
But your cost
Yes.
may not be imposed upon
Yes,
I am
it's
sorry
moved
for
item
that.
9.
But
Item
cost may
nine.
not be imposed, my lord.
Permitted to withdraw with
Dismissed as withdrawn. Right.
But cost may not be imposed, my lord.
Yes.
Item number 10.
Your Lordship may permit me to withdraw the same, my lord, so that.
Who's in item 10, sir?
Item 8, your Lordship. I am
Who's in
sorry,
item
madam.
10?
Item number 10.
None appears dismissed.
Item number 11.
May please, your Lordship. My lord, that has been settled amicably between the parties, my lord. I filed this application for questioning of the criminal proceeding, my lord. At flag C, the compromise affidavit, the counsel for the OPT is present here. Flag C, the compromise affidavit, my lord.
What are the offenses, sir?
Offenses under section 417, 420, 323, 493, 506, my lord, of the IPC.
Counsel for the opposite party number 2 confirms that the parties have settled their disputes. The affidavit of opposite party number 2 is also on record. In that view, the matter taken from the previous and all proceedings consequent that.
Item number 12.
Obliged.
My lord, liberty to approach the trial court requires the criminal proceedings. Case counter case. Dispute between cable operator. Offense is not made out to the CGA, causing of criminal proceeding, my lord.
Can urge all the pleas, madam, permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
Item 13.
None appears dismissed.
Item number 14.
Permitted to withdraw, my lord.
Dismissed as withdrawn.
Item 15.
This is relating to defreezing of bank accounts. At flag B, we have given a convenience note. And the court had also asked the state councils to take instructions. Wide order dated 20th November 20. The offenses are relating to explosive substances. So they may not warrant freezing of bank accounts. Had there been economic offenses, things would have been different. This is relating to explosive substances. Petitioner company provides those explosives. So it's nowhere linked to attaching the bank
What are
account.
the instructions? We have received instruction, my lord. Your Lordship may kindly see.
No. Under what provision are you seizing the bank account?
My lord, there are several transactions of this petitioner, my lord, with several persons, my lord. And the deposits made in the bank account, my lord, cannot be accounted for with regard to his known source of legal source of income, my lord.
Where is all that? That's nothing is stated here.
My lord, I am pointing out your nothing. Yes, my lord.
What is the procedure for freezing backwards? No, don't make me read all your files. Just come here. Come to the mic.
Yes.
Show me in law what is the provision for freezing bank accounts. Have you heard me, sir?
Yes, my lord. Yes, my
lord. What have I asked you now?
My lord, provision, my lord. So far as the provision.
It's there in that file.
My lord, the provision has not been mentioned, but the
No, forget mentioning. As a lawyer, have you studied this point?
My lord, I will check up, my lord.
If you check up the file, you will not get, sir. For law, you should check the file.
So far as the law is concerned, I have to check up, my lord.
What is the law on freezing of bank accounts?
Yes, my lord. There is a provision in CRPC, my lord. 102, na? 102. My lord, the 102, my lord. CRPC, my lord.
Yes.
My lord, power of police officer to seize certain property, my lord. My lord, any police officer may seize any property which may be alleged or suspected to have been stolen or which may be found under circumstances which create suspicion of the commission of any offense, my lord.
Come to subpara 3, subsection 3.
Yes, my lord. Such police officer, if subordinate.
Subsection 3, sir.
Subsection. Every police officer acting under subsection 1 shall forthwith report the seizure to the magistrate having jurisdiction.
Where is this report, sir?
Let the
When was it seized, Mr. Mishra? When was it frozen?
2020.
2020. No, which date?
Exactly. There are 7 bank accounts with regard to 2 police cases. So exact date.
The two things you have to tell me.
Yes.
The date on which you decided to freeze the bank accounts. Now that you have the file, you should be able to tell me.
Yes, ma'am.
Second, because section 102(3) requires it, you should forthwith report the seizure.
To the magistrate.
So show me how you reported forthwith the seizure. First, tell me the date and then tell me the date of your report.
Procedure list 60 to 63.
They pass it over.
Yes, my lord. You are saying pass it on. Let it come tomorrow, my lord. I will.
It's all right. Says now that you have the file, let us do
Yes,
it today.
Item number 16.
I'll raise all the point at the time of hearing the case.
All right, permitting the petition.
Item 17.
Item 17, your lordships, on behalf of Mr. B.K. Raj, I may be permitted to appeal. What's the matter? My lords, this is a case under section 138 of the NI Act. I have challenged the order of cognizance, your lordship. 2 transactions has been made by the opposite party to one MS Hare Krishna, a foreign mallards who deals with gold and silver ornaments. And 2 transactions has been made to the account of the firm. But mallards, without making the firm as a party to this case, the partners has been made as an accused.
Who has changed? Who has signed the check?
Mallards, the checks has been signed by one of these partners, but that was the check of the firm, mallards, not on individual capacity. The petitioner has issued the checks.
Where are the checks? Where are the checks?
Pardon, your lordships, the checks are not been annexed here, but it is there in the complaint petition, your lordships.
You'll have to annex them, sir.
There's no
You cannot argue a case like this without annexing the check. Copy of the check has to be annexed.
Your lordships, I'll be producing the checks. Let notice go to the opposite party.
Not like that, sir. You come fully prepared, then you can tell me what I should do. You first do what you have to do.
Lordships.
Where are the checks?
It's the checks has been annexed in the complaint petition before the court below, but mallards, in my petition, I haven't annexed this.
Client did not pay you enough fees for doing that.
Mallards, I'll be producing the checks.
Checks are worth how much? 26 lakhs, 30 lakhs,
Mallards,
30 lakhs.
Your lordships, 2 cases has been tagged up and a single case has been filed for 2 cause of actions. And the total tune of the checks dishonored is nearly about 2 crores.
You can point this all out at the stage of seeking discharge. You can point out all this, sir. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. All right.
Item number 18.
Item 18 may please. In that case, when it's the present petition challenging the order militia 31/10/122 passed by the law and JMFC that has been passed militia that the decree of divorce has been dissolved between the parties militia in 24/2/22 in annexure 1 militia. Thereafter, militia, the expert judgment has been passed in 5/10/2021. Thereafter, militia, in page number 20 militia, the page number 20 militia, that is the PW3, the elder son of the victim militia, the wife militia, they have been examined. He has been examined and he has stated that his mother has left the house voluntarily. They have stated that there is a little dispute between the by father and mother. Then mother is own will they have voluntarily left the house. They have thereafter that the wife has filed a matter in page number 59. They have stated that when the decree expected order has been passed, she was engaged in that is elder son's marriage. For that reason, she was not appear in page number 59. That is he was in the
in his house, for he was not appear in that court, my lordship. And in Annexure 1, my lordship, that he has stated that the decree has dissolved between the parties. He stated that page number 20, PW3, my lordship, Bhabas Kumar Patra, the elder son has been married, that he had deported. She stated that the little dispute has there between mother and father, my lordship, and mother used to leave house voluntarily. And only the mother is that the father is a government employee, state government employee, my lordship, that both the sons have been married. In his he has stated in his file, my lordship, matter case has been in page number 59. They have stated that his elder son was also both are the government employee, my lordship. They are only harassing the husband, my lordship. There is nothing reason, my lordship, only harassing the reason. One by one case being filed against the husband, my lordship. There, I have filed the my lordship stay operation. If notice should be sought to they will appear, my lordship. If there is no such
more harassment only, sir.
My lordship, even
only more harassment.
Only for harassing the husband, my lordship.
Now your turn to harass. It will never end. Harassment will never end.
Right.
So better not to start it.
If it will appear, my lordship,
the petition, you want to withdraw or you want to meet?
I want to have they will appear. Notice will sought to the.
I'm not inclined.
They will appear. They will sought.
I am not inclined, sir. You want me to pass the order or you want to withdraw?
Pass this order. Pass this order.
All right. Counsel for the petitioner. The petition challenges an order dated 31st October 2022, passed by the learned JMFC, LR Bhubaneswar, in CMC number 109 of 2022, rejecting the prayer of the present petitioner, bracket opposite party in the aforementioned case, bracket. Questioning the maintainability of the case instituted under section 12 of the Prevention of Protection of Women from Domestic Violence Act, bracket PWDV Act, and for the reliefs under sections 18, 19, 22, and 23 thereof. Paragraph. One of the grounds on which the application was questioned, the maintainability of the application was questioned, was that the marriage between the parties had been dissolved by a decree of divorce passed by the Family Judge Khurda on 5/10/2021 in CP number 42 of 2020. Paragraph. In the impugned order, it is noted that the said divorce decree was in fact questioned by the opposite party wife in appeal number MATA number 20 of 2022 in this court, and by an order dated 8 March 2022. The said divorce decree has in fact been stayed by this court. Paragraph. Despite the respondent filing the aforementioned application on 23rd February 2022, no reply was filed by the present petitioner, and instead only an application questioning the maintainability, and instead only the plea of maintainability was raised. The learned GMC has rightly noted that this was only to somehow delay the proceedings without allowing the court to proceed on merits. Paragraph. Having heard learned counsel for the petitioner, the court is not satisfied that any ground has been made out for interference with the impugned order. The petition is accordingly dismissed.
Item 19.
Dismiss, Melsi.
Yes, please.
I am permitted to withdraw, Melsi.
Item number 19.
Yes, I asked you. You said no. Pass an order.
No, my lordship. I just only just clarify that my dad, the court that only the decree of divorce has been passed, Melsi, only in.
It's all right. It's all right. All right.
Item number 19.
without allowing
Copy of this order be sent to the court concerned.
in this case, my lord, without allowing the cross examination of PW1, my lord, directly put up for argument, my lord, under Annexure 1, page 6, my lord. There is also no.
What is the offense?
Offense 138 in NI Act, my lord. Annexure 1, page 6, my lord. Kindly see. Complainant accused filed a time petition which is rejected. Cross examination of PW1 stands closed. Put up on it for argument, my lord. So
What happened in the, when was that order passed?
without adducing evidence, my lord, from defense side and without other formalities, my lord. Is required, my lord, for cross examination of
The challenge
PW1, my
is,
lord.
yeah, all right. Notice, you say notice returnable. For the roster bench. On 27 June. What happened on 20th April?
My lord, their argument is closed, my lord. Now put up for judgment. Judgment not passed, my lord.
All right. If no order has been passed yet, in 1 CC number 608 of 2010, it shall not be passed till the next date. A copy of this order be sent forthwith to the court concerned. Notice by registered speed post, the tracking report be placed on record.
Miscase for stay, my
You said that, sir. No order shall be passed.
Item number 20.
May I please your May I please? Am I audible to you all also, Lord?
Yes, please.
Lord, item 20, Lord, 69 and 79, the three matters, Lord,
yes,
in which I'll be appearing, Lord. Lord, these matters have come to me. These are basically quashing petition, Lord. Item 20 is quashing of a particular FIR, and item 69 is quashing of the SDGM order whereby that FIR is directed to be registered, Lord. And then 79 is another FIR filed by one of the person. The allegations are purely in civil nature, Lord, apparently. One is for non-grant of salary, 79, and Lord, 20 and 69, which are connected. They are arbitration matter in which the matter is arising from arbitration is taking place. My only request today is, Lord, there are three matters which have come to me late in the evening last night. Would you also be kind enough to accommodate me for one day, Lord, maybe tomorrow or day after, whichever date is suitable to your Lordship? I'll go through the brief properly and will be able to assist your Lordship.
So these are 2020 matters.
I agree, my Lord. Therefore, I'm only saying.
What has happened in the meanwhile? You tell me what has happened in the meanwhile in the court below. These are, you challenge an FIR. Obviously, it must have proceeded to the stage of charge sheet.
Well, there is a
charge sheet been filed.
Not filed, Your Lordship.
Because this petition is pending.
Yes, my lord. And
so why don't you help them file the charge sheet? Withdraw all this. At least they file the charge sheet. You will have a better case. Unnecessarily stopping them from completing the investigation.
No, Lord, I argue, Lord, it's a good case because it's a similar matter, Lord, arising from the similar transaction, another FIR that Jharkhand High Court has passed it, saying it's a civil matter, Lord. So I'll place all those materials on record, Lord. I'm only praying for one day so that tomorrow I'll have sufficient materials with me.
No. My point is, what has happened in these cases?
Lord, arbitration, in these cases, arbitration has taken place, Lord, and parties are actually exhausting all their. We are saying it's a
Mr. Ajay Kumar.
Please, Lord.
I'm sorry that I'm not making myself understood to you.
I'm so sorry, Lord.
In these criminal cases, what is happening?
Lord, in one of the matters, the proceedings have been, Lord, SDGM proceedings have been stayed by your Lordships by an order dated 6th of December 21. Lord.
In which case?
In item number 69, Your Lordship.
Number 69, Lord. Second matter, which is challenging the SDGM order under 156(3). In that, your Lordships have been kind enough to stay that proceedings, Lord.
On what ground, sir? What is the ground for stay?
One is the territorial jurisdiction, Lord. Entire affairs have stated to have taken place in the state of Jharkhand, which is Jamtara. And two, Lord, on the ground, it's a complete civil dispute. in which there is an arbitration provision, arbitration clause, and parties have already approached to the civil court. So these were the matters argued there, my lord, on which ground they have passed this particular order, my lord.
No, you are in Orissa very much. They came here and filed a complaint here. You are a resident. You are residing in Sundargarh district, right?
That's not me, my lord. I am the accused. I am seeking quashing of the proceedings, my lord.
What is your address, sir?
I am in Jamtara, my lord. Jamtara, Jharkhand.
I see.
Yes.
The complainant is in Sundargarh.
Yes, your lordship.
Yes, that's true.
I see.
There are some materials to be taken up into account, my lord. That's why I'm saying that 1 day or 2 day, whichever suits convenience of my lords, so that I have sufficient material to place before the lords.
Who's appearing in that other matter in which notice is gone? 1, 2.
My lord, I am appearing for the complainant, your lordship. My lord. Here, your lordship, in item number 20, the copy not served, your lordship. And in item number 69, I have the copy. They challenge the order of the learned SDGM, your lordship, where the learned SDGM pass on simple order to investigate the matter. And the investigation is going on. And they take the stay order from this honorable court, your lordship. Till now, the investigation is going on, your lordship. Without investigation, how the police came to the conclusion?
What is your complaint, sir?
Should I explain, Lord?
No. What I'm just asking the counsel of the complainant, sir.
My lord,
what's your complaint?
That is page number 21, your lordship. Complainant inquire about the balance of joint account bearing number this and this, main branch Jamtara, Jharkhand at SBI Bazaar branch, Sundargarh, and came to know about the illegal transfer of 24 lakhs to other account without his signature. And
Are
on
they
us,
all partners?
Yes, your lordship, they are partner.
No, they are not partners, Lord. There is an agreement whereby the work has been deputed to him as far as that part is concerned, in consideration, and therefore all those questions are being decided by the arbitrator. The matter has been referred to the arbitrator. They are looking into it.
Is that true? You are in arbitration.
Arbitration proceeding is going on, your lordship, but in Kania,
it's all award is passed already. Has an award been passed in the arbitration?
Lord, I have no information on the award. I'll get those details.
You will know?
I will take all instructions. In item number 79, your lordship, that is a different matter.
I'm so sorry, Lord. I couldn't hear.
Yes.
In that matter, your lordship, the operator lodged the complaint, saying that 1 crore 2 lakhs has been duped by the present accused person, petitioners, your lordship.
Whose operator means?
The complainant Kausal Sahu. In item number 79, your lordship.
No, you are appearing for the complainant that also.
Yes, your lordship.
Aha.
The complainant lodged the complaint, your lordship, on 17 March 2021.
Lord, page 17, their complaint says that their salary has not been given to them. Now, I have something to say on that, Lord, but today I have no instruction at all. So I'll have to obtain instruction, Lord, and make submission on that.
Counsel for the petitioner in all these matters. Counsel for the petitioners states that he's recently been engaged and needs time to prepare for arguments. Counsel for the complainant also needs time to appraise the court of the outcome of the arbitration proceedings, stated to be ongoing. See list before the roster bench on 3rd July. Interim order to continue wherever passed.
Interim order is there.
Item 21.
Now, item number 79, there is no interim order, your lordship.
Yes. Who's in 21?
Item 21.
No. None appears dismissed.
Item 22.
My pleasure, Lordship. Lord, here prayer is for questioning of the proceeding because of the settlement between the parties. Annexure 2, page 16, Lordship may kindly see. The complainant filed a affidavit before the learned court below that she doesn't want to pursue the matter further because the allegation is that there was love relationship and
You are for the.
I am for the OP2, my lord.
That's right.
The victim. Yes, my lord.
All right. Counsel appearing for OP number 2 confirms that there is a settlement arrived at between the parties and that he has no objection to the quashing of the criminal case. It's 376, sir.
Yes, Lord.
There's a question of.
Well, that was the allegation, but she denied for medical examination. That is also the observation of the learned court below.
That's all right.
She denied for medical examination and
Sorry, sir, that's a
subsequently,
different issue then.
subsequently both of them has got married, Millard. They have married.
The victim may also married
married.
elsewhere.
Where is the affidavit?
My lord, affidavit is filed by my learned friend, my lord.
I have filed the invitation card, annexure 4, page 23. Lords may kindly see. Because keeping in view the marriage of the victim
Let
was
the victim file a proper affidavit. Sorry.
The affidavit filed before the trial court, my
Appearing for
lord.
opposite party number 2 enters appearance. A proper affidavit of opposite party number 2 be filed
Obliged.
before the next date. List before the roster date. On 10 July.
let there be a stay of the further proceeding.
It's made clear there is no stay of proceedings. A copy of the order be sent to the court below.
Item 23.
None appears dismissed.
Item number 24.
None appears dismissed.
Item number 25.
None appears dismissed.
Item number 26.
None appears dismissed.
27.
Same order.
28.
Same order.
29.
Same order.
Item 30.
Same order.
31.
Same order.
Item number 32.
My lord, I will raise all the points before the trial.
Permitting the petitioner to raise this.
Item 33.
Memo taken on record. Dismisses withdraw.
Item number 34.
May it please the Lord. Challenging the FIR and initiation of criminal proceeding, Millard. Only 2 points are for the Constitution. One is the present petitioner, the accused is a Dr. Millard, and FIR is registered without obtaining expert opinion for medical negligence. And second is the FIR is registered under section 304A, where the patient is alive, Millard. Let's see, may turn to page 5 of my petition.
But this is 2020. What has happened in the last 3 years?
I will take instruction, Millard.
All right. At the request of counsel to petitioner, who needs time for instructions on what has happened in the meanwhile. List on 12 July.
Obliged.
Item 35.
None appears dismissed.
36.
Same order.
Item 37.
Same order.
Item number 38.
Memo taken on record. Dismissed as instructions.
Item number 39.
My lord, on behalf of Mr. Bharat Jali, my lord, the matter is amicable, settle both the party, my lord, and the informant does not proceed this case, my lord.
I am appealing for the opinion 2, my lord.
Commission offense only 392, my lord.
All right. Counsel appearing for the opposite party number 2 confirms, enters appearance and states on instructions.
Also filed an affidavit, ma'am. I also filed
and tenders an affidavit stating that she does not wish to that he does not wish to pursue the case against the petitioners. That we might take to the prayer clause and all proceedings consequently.
Item number 40.
My lord, item number 40 maybe kindly be adjourned to next week. My senior has gone to Hyderabad. The file is not with me.
It's okay. Counsel with the petitioner states that the file has been misplaced.
No, it's in a chamber. I don't have the file. He has my senior has gone to Hyderabad.
So okay, sir. Whenever you get the file and time, you can come and revise.
Next week.
You say, what's the matter about? 107. You say these are proceedings emanating from proceedings under section 107 CRPC, filed way back in 2020. Given the passage of time, the cause of action obviously does not survive. The petition is disposed of.
Item 41.
None appears dismissed.
Item 42.
None appears dismissed.
Item 43.
Same order.
44.
Same order.
Item number 45.
Same order.
Item number 46.
Same order.
47.
7, my lord, permitted to raise all those points.
Permitting the petition to raise up, please.
Item 48.
None appears.
Item number 49.
None appears.
Item number 50.
It please, Your Lordship. Your Lordship, on 27th April 2023, Lordship passed an order in CRLMC number 27 of 2023. The matter apropos to whether the chemical examination is the preliminary evidence or not, without taking the note that there is no chemical examination report, and the learned special court framed the charge in that matter, Your Lordship. Similar to this matter, Your Lordship. The chemical examination is the preliminary base in this matter, Your Lordship. Without chemical examination, how the learned court below came to the conclusion that this is a contraband and or this is a.
But similar item, I think we've already passed that the other day. 1,000. This is that
1,100 kilogram
of ganja. I think you've dismissed it.
They're saying that this is ganja, Your Lordship. But without chemical examination report, if they taken cognizance, that is illegal. And if they frame charge, that is also fallacious, Your Lordship.
Very good.
Your Lordship pass and sought order in this matter also. If the petitioner agreed, then.
But we've already passed that order.
In that matter, Your Lordship, that is CRLMC number 27 of 23. And this is CRLMC number 45.
Yeah, but the same FIR, right?
No, that is different FIR.
Oh, I see. All right. You see, the present petition has been. No, the challenge in the present petition is to an order dated 30 June 2022. Passed by the learned session judge cum special judge Berhampur in 2A CC case number 49 of 2021 bracket N You only come against the cognizance order.
Yes, Your Lordship.
Taking cognizance of the offence under section 20, bracket small b, small Roman 2, bracket C of the NDPS Act 1985 against the petitioner. First, by the outset, must be noted that the petitioner is one of 4 of the accused. It's only by one, no? Here?
Yes, sir.
Who were implicated. Who have been named in the aforementioned case for alleged contravention of section 8 of the NDPS Act. No, for being found in possession of $110 kgs of contraband ganja. On 21st September 2021. In a motor vehicle in which they were traveling. So it must be mentioned here that the petitioner has already been enlarged on bail by the trial court by an order dated 21st March 2022 upon failure by the prosecution to file a charge sheet within the mandatory period of completion of 180 days from the date of arrest. A perusal of the impugned order dated 30 June 2022 reveals that the inspector of the district citing post Berhampur, who also is the investigating officer, bracket IU, submitted the prosecution report to the trial court, on perusal of which the court was prima facie satisfied of the commission of the offence. Paragraph. It is sought to be argued that cognizance could not have been taken by the trial court of the aforementioned offence against the present petitioner, since the IO did not enclose with the charge sheet the relevant chemical examination report, which according to counsel the petitioner is the foundation for a case of this nature. Paragraph. An inspector with striking force has been assigned with the special duty of detecting cases of involving offences under the NDPS Act and has usually vast experience to move swiftly after coming across reliable information. Stop. The complaint itself notes that the patrolling party chased the car in which the accused were traveling. And there was a strong odor of ganja coming out from the car, which contained 4 jerry sacks. Which upon weighing revealed that 110 kg of contraband ganja was being transported. At the stage of taking cognizance, the court had to be satisfied that a prima facie case had been made out, attracting the aforementioned offense. The quantity being a commercial one. And given that the seizure was by a specialized team dealing with cases of narcotics, the mere failure to the mere absence of a chemical investigation report at this stage would not vitiate the order taking cognizance. Consequently, the court is not inclined to interfere in the matter at this stage. Petition is accordingly dismissed.
Item 51.
Grateful.
51, my lord, liberty may be granted to raise all this point at the time of trial.
All right, permitting the petition.
Item number 52.
None appeals dismissed.
Item 53.
Same.
Item 54.
54 also, I'm seeking liberty to raise all this point.
Permitting the petition to resolve.
Item 55.
None appeals dismissed.
Item number 56.
None appeals dismissed.
57.
May I please? Lordship, the petition is challenging the order of NBW. Your Lordship, the offenses
What's
are
the offense, sir?
307 and other offenses, Lordship.
What is other offenses?
Other, there are 5 persons are involved in the crime, and out of 5, 3 persons got arrested and they are on bail, Lordship.
Read the search, sir.
Was
First,
only-
Armed Weapons Arms Act.
Lordship.
You opened fire clearly.
No, only so far the Arms Act is concerned, Lordship, only the petition number 1.
Is it a gun or what?
No, only one. No, they have not utilized only the
What was your weapon, sir? What was the weapon? Is it a gun?
In fact, the dispute with regard to the 2 related families.
All right, sir. The relatives only use the most powerful weapons. Not inclined.
Lordship, faster set of parity, Lordship. Others have been released on bail, Lordship.
You surrender, sir. You surrender. You want to withdraw, do that.
Permitted withdraw, Lordship.
Constable petition seeks slip to withdraw the petition. Put down the prayer clause. Dismiss is withdrawn. A copy of this order be sent to the concerned court.
All right.
4 years you've avoided, sir.
Yes.
You are a big dada, clearly. Yes.
Item 58.
Withdrawn. Dismiss is withdrawn. Again, put the prayer clause.
Item 59.
Sir, all these matters,
yes,
setting out prayer clause and all that, will you make? If they again file a similar petition in 3 months' time, how will you know?
Well, the earlier filing, number of this earlier filing will come along with that new filing. Right? It will come, my lord. And certificate is to be given by the petitioner.
Declaration. They have to
that this matter was not earlier before this honorable court. If
It is neither here nor there.
in the filing counter, this can be pointed out, my lord.
See, what they say below the cause title is the matter out of which this criminal miscellaneous petition arises was never before this court in the present form whatsoever as per instruction obtained from petition number 1. This is all very convenient. And this is not with the affidavit, it's not part of the petition.
Lord, when the second application will be filed, challenging the said same cognizance order, the filing counter will point it out that it was earlier filed.
No, but why should the party not promptly say that and annex the copy of the order? Well, you say the court finds that in petitions filed under section 482 CRPC. This is this matter, right? हाँ गीता रानी से बता. While seeking the quashing of criminal proceedings, there is no declaration in the petition itself that no earlier similar petition under section 482 has been filed arising out of the same criminal case. Full stop. There is also no requirement to mention the number of such criminal case and the order passed therein, in case there was an earlier similar case. Full stop. This is a necessary and material fact that is required to be stated on affidavit by a petitioner. Full stop. It is not sufficient that the registry itself, by checking the system, makes a note of it. Full stop. Paragraph. Secondly, the court finds that in a petition under section 482 CRPC, the prayer clause sometimes includes prayer for grant of bail, public interim bail, and so on. Full stop. There are separate provisions of the CRPC for such purpose. And therefore, the registry should point it out as a defect if the prayer clause includes prayers of grant of bail, interim bail, etc. Paragraph. Practice direction incorporating the above two directions be issued by the registry. Forthwith.
Item number 60. Item number 60.
None appears dismissed.
61.
May I please, your lordship. The petitioner here challenging the order of cognizance dated 4/9/22. My lord, here the petitioner is a lady and the public servant, my lord. My lord, here my humble submission is that The learned SDJM not before taking the cognizance, the learned SDJM not taken the sanction under section 197 of CRPC, my lord. Where the 197 CRPC says the prosecution of judge or any public servant when any person who is or who was a judge or magistrate or a public servant not removed from his office, save by or with the sanction of the government, is accused of any offence alleged to have been committed by him while acting or purporting to act in the discharge of official duty, no court shall take cognizance of such offence except within the provision of sanction. Here in this case, the learned SDGM not took the sanction before taking the cognizance.
The provision doesn't say cognizance can't be taken.
My lord.
Where are you reading 197, right?
My lord.
Let's read 197.
197 CRPC, my lord. Subsection 1, my lord.
So, offense alleged to have been committed by him while acting or purporting to act in discharge of official duty. So, what is the complaint here?
My lord, petitioner is the working lady under TPCODL. As per the FIR, my lord. During the survey in village of the complainant, there is a hot word of exchange between the TPCODL authorities and the villagers. And the scene is occurred. That is the only thing. And FIR lodged against under section.
So cross
341, 294 and
so cross
323.
FIRs have been lodged.
Yes, my lord. There is a counter case is there. Under Annexure 2, my lord.
No. Annexure 2 is the case lodged by you or by the other side?
Lodged by petitioner, me.
Where is the case lodged by the other side?
Other side, Annexure 1. Page, my lord, 31.
Satyaranjan Sahu.
On 3/6/2022, villagers of Palasai, one Satyaranjan Sahu and other appeared at PS and reported in the writing to the effect that 29/6/2022 at about 12 noon, 3 persons of
this TPNODL, how is it a public servant?
Yes, my lord, there is a regulation. Kindly have a glance to Annexure 4, my lord, page 39. Annexure 4.
No, how is she a public servant?
There's a 51 equity shares of TPNODL Limited license for the distribution of retail supply of electricity.
No. So acquisition is mere acquisition is not.
They are considered to be public officers.
Where is that? Where is that? The whole idea of privatization was only to take them out of this ambit.
I'm showing my lord.
So Tata Power has in fact acquired 51% stake in TPNODL. And Gridco holds only 49%. In fact, it says when any person who is or was a judge or magistrate or public servant not removed from his office, save or by with the sanction of the government. This person is not removable by sanction of government, sir. He is not
Hello.
removable by sanction of government.
And the only thing is, I'm not satisfying a lordship. The petitioner is a public servant. Or not.
That's the main ingredient, sir, of 197. The whole idea of privatization is that they are no longer public
There are
servants. Sir.
lots of judgments covered by this honorable court
On TP and ODL.
that they are the public servants.
Who's TP and ODL?
Yes, my lord.
No.
They are doing public service.
Don't confuse things, sir. Everybody does, even lawyers are doing public service.
Hello, kindly keep it to tomorrow. I will bring you some.
What will you bring?
I'll bring some documents. Also provide some judgments.
What judgment, sir? This acquisition took place on 1st April 2021.
Hello.
Tata Power acquired 51% stake. Anyway, look at the section. You should be removable from service only by sanction of the government. You're not such a person, sir. Your designation is lady officer.
Yes, my lord.
You're not a public servant. You're not a, sorry, yeah, public servant. Better thing is you withdraw this, raise all pleas at the appropriate stage.
Okay.
All
right.
Permitting the petitioner to raise all pleas at the appropriate stage. Right.
Item 62.
Well, liberty may be given. Item 64.
FIR under section 376 and 506, my lord. I'm not pressing for quashment at the 2009 case, my lord. NBW is pending against me. I pay for
376. In a 376 matter.
Yes. 2009 matter, pay for first hour and second hour on surrendering, same day disposal.
Not inclined, madam. You have to surrender. Someday law has to catch up.
Yes.
Someday law has to catch up with you. What do you wish to do? You wish to withdraw, or you want us to dismiss it on merits?
Withdraw it.
Dismissed as withdraw. Put down the prayer clause. That's it. Copy of this order be sent to the trial.
Item 65.
In Bhatwal from Bhadrach. In Bhatwal from Bhadrach, my lord.
Yes.
I have filed this petition 482 CRPC against the charge framed by London Additional Session Judge Constitutional Bhadrach, Oxo Court.
Yes.
My submission is, my lord, in the affair, in the entire one statement, my name, Manila Bara, does not appear. Nobody implicated me in any manner. However, such submission orders 363 and 368. I filed a petition order 227 of CRPC to discharge the accused as there is no sufficient ground to proceed with against him. No evidence, no prior facie evidence, nobody implicated him. But however, London Assistant Session Judge inclined to discharge for offense 363, not 368. So I have come up with my lord, report Honorable High Court. Kindly.
The victim is just 15 years old.
Hi, my girl, while Kartiki Bara, the accused has kidnapped her. Only on the statement of the accused, he has been transited. I have annexed the statement of the accused.
Let it go to trial, sir. Let it go to trial.
I am against charge of them. No prior, no sufficient ground to proceed with. a old man of 75, 76.
No, 70 years.
Yeah.
70 is not very old, sir.
Of Bengal, what Medinapur, Bengal. So I said, no evidence. Zero evidence is zero. No allegation. Only basically the statement.
Then you get acquitted, sir.
So why shall I go for the trial for 2 to 3 years?
Only because it's a 15-year-old girl who's been kidnapped, raped because of that.
That is there. Yeah, no allegation against me, sir.
That will all come out in the trial, sir.
It is a case not there, sir.
Not inclined, sir. Not inclined. What do you wish to do? What do you wish to do, sir?
Merit may pass.
All right. Petition is dismissed. We'll pass the detailed orders.
Item 66.
May I please, Your Lordship?
Yes.
Alleged offences under section 341, 294, 323, 506 and 34 of IPC.
Yes.
In this case, we are come to this honorable court praying to quash the affair and subsequent proceedings.
Yeah.
That's it. In this case, the entire allegation, the affair is unknown affair, Lordship, and the petitioner names has included in the 161 statement, Lordship. And there is a very complicacy in that. My Lordship, kindly glance to page number 7, annexure 2, the last para in Odia. Mention that ମୁଁ ଆପଣଙ୍କୁ ଜଣାଇବାକୁ ଚାହେଁ ଯେ ସେମାନେ ଆସିଥିବା ପିଲାମାନେ ହେଲେ ନଣ୍ଡା କାହ୍ନା କିରଣ ପ୍ରଭାତ ବାତ୍ୟା ଭୀମ ରାଜା ଗାନ୍ଧୁ ଓ ଅନ୍ୟମାନେ ମତେ ଖଣ୍ଡାରେ ହାଣିଥିବା ପିଲାର ନାମ କାହ୍ନା ଅଟେ. This is the allegation in English, my lordship. I want to inform you that those culprits are nanda kanna kiran prabhat batya bhimo raja gandu and others. My lordship, in this case, though Kanha, though this petitioner's nickname is Kanha and the Prabhat, whose nickname is Kanha. Prabhat is already arrested and released on bail, my lordship. Kindly glance to page number 15, my lordship.
Where are you? You're arrested or you're not arrested yet?
Oh, my lordship.
Taking chance.
Lordship, I'm not that person.
All that. What are you doing, sir? You filed for anticipatory bail. What have you done? You're not in bail. You're not arrested. Mr. Filed anticipatory bail.
Police are deliberately disturbing me, lordship.
So what have you done? You filed anticipatory bail.
Lordship, this petitioner is not involved in this case. So that's why.
What have you done, sir? In the sense, we're not asking about your involvement. In the sense, have you filed an anticipatory bail application?
That's why I don't want to include in this case, lordship.
What are you saying, sir? You're already named. That's why you're coming to the court. Correct?
No, lordship, my nickname is Kanha. This petitioner's nickname is
If you don't
Kanha.
want to understand, my English is very poor. It's not as good as yours.
Sorry, lordship.
So I have to repeat myself twice or thrice so that you can understand. You have not been arrested so far, correct? Have you been arrested, sir?
No.
So when you're not arrested, what do you do as a lawyer?
It's apprehension of arrest, lordship. Police personnel are.
So what will you do?
Come to the honorable court by filing an anticipatory bail.
Have you done that?
No, lordship, the last occasion I have filed a anticipatory bail without a FIR, lordship. Though this honorable court had taken instruction from concerned PS whether a FIR has lodged or not. But the police intimated that there is no FIR against the petitioners. But police personnel intentionally disturbing me. That's why we come to this honorable court.
482 is how is that? 482 an answer for that?
My lordship,
How is 482 an answer?
my lordship, give me liberty to surrender and.
Why? We need liberty to surrender, sir. Please. The new concepts. What do you want to do? Tell me. You're now seeking quashing.
My lordship, first half, second half, or maybe first half, second half, madam.
That's not for 482, sir.
Permit me to withdraw.
Counsel to the petitioner seeks leave to withdraw this petition. Dismiss this withdrawal. Put down the prayer clause.
67.
Yes.
Item 67.
Lordship, I'm appearing virtually. I may be allowed. My lord, this matter pertains to defreezing of accounts of this petitioner arraigned in a case under section 13(2) of the Prevention of Corruption Act, your lordships. if your lordship sees page 4 for a moment, the table points out 4 accounts, your lordships, all belonging to the petitioner, except your lordships at serial number 3, the account, it's a joint account, my lord. Petitioner, my lord, is made and accused by virtue of the offense committed, which the principal offense has been committed by the petitioner's husband, who was ex-SDPO, Dhenkanal, your lordship. So far as this case, my lord, is concerned, my sole bone of contention is that the procedure under Section 18A of the Prevention of Corruption Act, my lord, which has been inserted by virtue of 2018 amendment, has not been followed, your lordship. So if your lordship kindly sees 18A. Wherein it stipulates that the provisions of Criminal Law Amendment Ordinance of 1944 shall be applicable. Now that ordinance, my lord, proposes for the procedure where an application is to be made first for an attachment of property before the district judge, and thereafter an order being passed, the attachment is permissible, my lord. That procedure has not been followed, your lordships. And I rely upon...
The investigation is not complete. How can they order defreezing, sir? That's the whole problem.
Lord, if I'm relying on the Honorable Supreme Court's judgment in Ratanlal Babulal Rath, my lord, when the procedure itself has not been followed. That, my lord finds it. Grateful, my lord. It has been followed by
that Ratanlal Babulal?
Lath versus State of Karnataka, my lord.
Where is that?
If your lordships allows me to screen share, I can share that. The coordinate bench of this honorable court, my lord, takes note of that at para 6. Lordship, I have shared the screen, my lord.
What do you say?
My lord, it's like an application here challenge the application, rejection of application under section 457 of the CRPC, which is revisable one. So 482 is not maintainable.
Right.
Second aspect is, with all fairness, I submit that 18A has not been complied. It's a DA case. And 18A has not the procedure laid down under section, it has come after amendment, 2018 amendment, 18A has to be followed for freezing of the account. So with all respect, what I submit, your lordship, then come to I'm relying on judgment, whether at this stage, in a DA case, the accounts can be released. So far as your lordship may consider, subject to your lordship's kind consideration, keeping the balance as on date of search. Which
what balance? What is the balance?
Balance as on date of search that your lordship kindly turn to, kindly say, that is, that the accounts as it depicts, that is one account that is 44,000 some odd, another is 1 lakh some odd, another is that is for something 44,000 something. So that is there. So another aspect is, so far as out of 4 accounts, one belongs to the husband of the petitioner who happens to the principal accused, and in the petitioner cannot claim for that. And the same cannot be released in respect of the petitioner. Another aspect is the joint account.
Then you file a reply, sir.
My lord.
Counsel for the petitioner states that the petitioner is the wife of the person facing proceedings under the Prevention of Corruption Act 1988 for alleged possession of assets disproportionate to his income. It is prayed that since there is non-compliance with the mandatory requirement of Section 18 capital A of the Prevention of Corruption Act as amended in 2018, the account should be defrozen. Paragraph, counsel for the state, on the other hand, states that there are 4 accounts and one of it is exclusively in the name of the petitioner's husband and cannot be defrozen. He undertakes to file a reply to the petition to point out what according to him requires to be still frozen in the accounts. An affidavit be filed by the respondents within 2 weeks with an advance copy to counsel for the petitioner. Let's look for the Rajda bench on 16th May.
Grateful.
Item number 68.
None appears dismissed.
Item number 70.
Same order.
Hey, my lord. I am in virtual. Well, in spite of my trying to take note what is the stage of trial, I could not obtain the. Anyhow,
So you will reserve all your pleas at the appropriate stage.
Yes, my lord.
All right. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. The interim order is vacated. All right.
Item 71.
None appears dismissed.
Item number 72.
72, I pray my lord, liberty be given to raise all points at the time of trial, my lord.
All right. Permitting the petition.
Item 73.
73, my lord, may I praise?
Yes.
Here, my lord, I have filed a 9/9/2018 alleging there is vandalism in my office. I am a transporter. My office has been vandalized by the truck. Then, as a counterblast, an FIR was filed by the wives of the truckers, the owner of the trucks. That was my FIR was registered as 138 of 11/9/2018. Their FIR was 139. Now, in that FIR was investigated upon. Your lordship can come to page 37 of the final report, final form. In that 139, which was filed as a counterblast, your lordship can have. This has been closed for no case. Your lordship kindly turn to page 37, paragraph 16. May I
Yes.
Yes. That on 12/9/2018, that I would say on written complaint recorded by Sanghamitra Devata, wife of so and so, so and so, so and so.
False case, it says. All right.
Yes, my lord. And neighboring witness doesn't support. Then, my lord, without showing how this police person is wrong, they have filed a fresh 1cc case by changing the story, by adding some news to completely.
But they've also filed a protest petition, sir.
Yes, ma'am. That protest petition, they have abandoned what is the same person who has filed the complaint, the protest petition is also the informant. The informant did not whisper about anything which has been now been developed by way of this protest petition. And accordingly, the cognizance has been taken.
No, but notice earlier must have gone in this petition.
Yes, my lord, it has gone and there was interim order operating.
Then one Mr. Parthasarthi Das is appearing.
I am appearing for my lord. If the cognizance was taken in a protest petition, my lord. So kindly have a glance. So there is a case under session. The 10:38 night they enter my house, my lord, and for 354, 457 other offences there, and cognizance was rightly taken, my lord, in a protest petition, my lord. And this is need, my lord, trial because, my lord. Kindly have a glance to the protest petition, my lord.
What happened to your FIR against him, Mr. Ratha?
Yes, that has been charge sheeted. That has been charge sheeted.
Oh.
That ended in charge sheet. That is why this is the counterblast.
No, that is not that, my lord. That in the same night, the entering without my presence of husband, man, they came to my house and answered, my lord. The lord kindly have a glance to the.
And since both of them are in the same locality and doing the same job, I was actually asking my friend, they can come forward for a settlement. I am ready to. On these small petty offences.
What is this? What do you say, Mr. Das?
Yeah, I have take instruction, but there is no instruction, my lord.
All right. Mr. Ratha states that since given the nature of the complaints by one party against the other, there is a possibility of settlement of the disputes. To stop counsel for appearing for the informant needs time for instructions. Let's go for the roster bench on 5th July.
Interim order to contact.
Interim order to contact.
Item note 74.
Please, your lordship. Petitioner is the husband. In this case, maintenance order was passed to give 6,000 per month to the opposite party. The petitioner paying regularly the maintenance.
This is only interim maintenance, sir.
Let's see. Subsequently, annexed to session judge, Lord and session judge passed the judgment and deducting the same from my salary, lordship. But I pay regularly by cash, lordship.
What difference does it make, sir?
Therefore,
What difference does that make? Nothing.
I pay the maintenance in cash by.
It's all right. It's all only interim maintenance. Considering that what has been asked to be paid to the respondent opposite party wife is only interim maintenance, and that would only be 6,000 per month. The court is not inclined to interfere. The court notes that the petitioner is a government servant. Working as? What are you working as, sir?
The handicapped person, lordship.
As a male overseer of the postal department, the Digabahandi zone. Consequently, no ground is made out for interference. The petition is dismissed. The interim order is vacated.
Item 75.
May I please, your lordship?
Yes, please.
Here, your lordship, petitioner is the proprietor of a gas agency, your lordship. She filed this case challenging the overact of the Muniguda police by initiation of a false case against her. My lord, kindly peruse Annexure 3, wherein the FIR was lodged against me, your lordship, and the London court below taken the cognizance also.
Who's appearing for the informant? Have you served them, sir? Notice was issued way back on 19/11/2020.
Twice this matter was listed before the London court, before the Sonal court, but the opposite party did not choose to file any affidavit.
No. Have they been served?
My lord. My lord.
Have they been served? As the opposite party number 2, Petroleum Corporation, BPCL, right? Or HPCL?
No, this is not HPCL, your lordship. HP gas, LPG gas, your lordship.
HPCL, sir. The company is HPCL.
Yes, sorry, my lord. HPCL.
Have you served HPCL?
Yes, your lordship. Already is served.
Who is appearing for them?
Is Annexure 6, your lordship. You see the opposite party number 6. I've already issued the notice. As per my lord's order, I already taken the steps, your lordship.
How is it nobody's appearing? Do they have a standing counsel, this HPCL and all? Appears despite service of notice. Are you sure? It's opposite party number 6 is service. Appears that HPCL is served way back. The opposite party number 6, HPCL, was served way back in December 2020. But for some reason, nobody's appearing for them today. Fresh notice be issued to HPCL. Opposite party number 6, HPCL. Returnable before the Rochester bench in the next date. By registered speed post, the tracking report be placed in record. Interim order to continue.
Obliged.
List on 9th August.
Item 76.
None appears.
77.
Madam, 77,
Yes,
I have prayed for passing of annexure 4.
yes,
That is the proceeding under 107 of CRPC.
yes. That now nothing survives.
My lord,
These are all temporary proceedings,
my
madam.
lord, that is true, but during the pendency of the civil suit and in spite of
No,
the order
but
of
this
the
whole thing is meant to last only for 6 months. It doesn't last beyond that. At this
Of
stage,
course,
there's
I
no point
cannot,
interfering.
of course, I cannot say what is the right now, what is the status of the
Because
case.
this is not meant for the 107 and all is for very limited duration.
Then your lordship may pass
All right.
the order.
You see, the proceedings emanate from proceedings initiated under section 107 CRPC, which by its very nature is of a temporary duration. Consequently, there is no need at this stage for the court to interfere. Full stop.
Oh, bless.
The interim order is vacated, the petition is dismissed. All right.
Item 78.
Memo taken on record, dismissed as interruptions.
Item number 80.
Here is the case, my lord. My lord, the in-laws members filed the 482 applications to pass the proceeding. My lord, only allegations, my lord, the mother-in-law not allowed her son and daughter-in-law to go outside within the 15 days of marriage. And on the other hand, the husband filed section 9 application. And in the section 9 application in pre-conciliation, my lord, the husband my son ready to take back the complainant. My lord, your lordship, kindly see the report of the coordinator. I got the certified copy.
Pardon, lordship, I am appearing for the complainant.
Hmm.
And the opposite party number 2 to this application. They're saying that they challenge the criminal proceeding, but they're challenging the order of cognizance in this matter.
My lord, adding of old parents,
Page number 9 and 10.
old parents, and your lordship kindly see the thereafter the present affair. Your lordship, my lord, I had my son filed section 9 applications before the family court, and the coordinator, my lord, directed both the parties to stay together in his quarter at Bhubaneswar, and both the parties, my lord, staying there. And thereafter, your lordship kindly see what the complainant said. I could not say, my lord, in open court. Your lordship kindly see. Thereafter, the present affair.
Anyway, obviously, they can't see eye to eye, sir. What are the proceedings now between DP Act and IPC?
Yes, your lordship. The Dowry Prohibition Act.
Where is she staying now? She complainant?
Your lordship. Beg pardon, your lordship.
Where is she staying, sir?
Sir, at her mother's house, your lordship.
Which is in?
Barampur, your lordship.
Barampur. How old is she?
34, your lordship. 33, 34.
So the husband is not among the petitioners here?
No, lordship. No, lordship. No, my submission before your lordship.
And there are children?
My lord.
Are there children in the marriage?
No issue.
No issue, I think.
Oh.
No issue.
So you want to pursue the case against all these petitioners?
Your lordship, there is an allegation, my lord.
Allegation will always be there, sir.
For
you really wish to pursue?
Your lordship,
the divorce proceedings are on.
Yes, your
lord. My lord, divorce, my instruction, my lord, last 3 months, my lord, divorce proceeding is on. My lord, they are taking time, my lord, in divorce proceeding. My lord, my son, my lord, agreed to take back. My lord, she did not agree.
And if she give a bad statement, I could not say before your lordships in open court.
That is allegation. Nothing.
No, that is the report of the coordinator. I got the certified copy placed before lordship. And the present petition number 1, my lord, old mother-in-law is at about 75 years and unmarried.
Why did you try? Have you tried mediation?
Yes, your lordship.
Where?
In the mediation center.
Where? In the High Court?
In the High Court.
Oh, when was that? When did it happen?
No, mediation proceeding not initiated, your lordship.
That's
if
what
your
I'm
lordship
asking.
direct, then if your lordship direct, then
High Court mediation center, my lord, your lordship, only my lord.
The parties should attempt settling the disputes through mediation at least once. They are directed to appear before the High Court Mediation Center at 3:30 p.m. on. When do you want to go? 11th May?
My lord.
11th May.
Your lordship, some difficulties is after 15th May.
After 15th, all right. 18th?
Yes, your lordship.
18th May.
For the transportation and other expenses may kindly be bear by the petitioner.
For whom?
Your lordship.
Mediation. For mediation,
The
what?
Petitioner is
There is
not.
there is no income for the
Berhampur to coming to Cuttack is nothing.
Old
sir.
mother-in-law, my lord, 75 years old man. my lord.
The issue at hand is, my
You
lord,
want to go to the mediation center? And where are you people?
they are also from Berhampur.
Berhampur.
So you wanted to go to the district court there, mediation
Yes,
center?
my lord, my lord. They are my lord.
All
better.
right, at the
Better.
district court mediation center.
My lord.
Considering that both parties are in Berhampur, is directed that they will appear in the district court mediation center at Berhampur at 3:30 p.m. on 18th.
My lord.
The report of mediation we place before this court before the next date.
My lord. Interim order continue.
Yeah, interim order to continue. 19 July, sir.
My lord.
But your lordship,
Returns.
the issue is different in this matter, my lord. They challenge the order of cognizance.
It's all right, sir. They're all sisters-in-law and mother-in-law.
My lord, my lord. Grateful, your lordship.
May I pardon to one mention, my lord? Item 56, I have leased the file. Therefore, a non-person dismiss. Kindly be taken up next week.
We'll say we'll permit you to revive it, sir. Whenever you find the file, you revive it.
Lordship, trace matter. I just now received, I released the niece, my lord.
Kindly say misplace the file. Is permitted to revive it as soon as he finds the file. That's all. Simple.
Lord, may early next week. Lordship, tomorrow I lordship fix.
You file an application saying I found the file. That's the end of the matter, sir. We'll take it up immediately. Right.
Pastoral matter item 15.
I had intimated the state council in this. During the pendency of the 482, they have actually defreezed.
Oh, so this doesn't survive.
No, doesn't.
All right. Senior counsel for the petitioner states that during the pendency of the present petition, the accounts have been defrozen. The petition therefore does not survive and is disposed of.
We are grateful.
All right. Sometimes a Passover helps. All right.